The Senate Judiciary Committee will come to order. The clerk will call the roll. All in favor, vote aye.
You have a quorum, Mr. Chairman.
Okay, thank you very much. The first thing we're going to do is to certify judges that we've already interviewed. You should have on your desk the list of these judges. If nobody has any objection, we'll just go ahead and
Mr.
take
Chair.
it up. Yes, who's this?
Morrissey.
Cynthia Morrissey. Okay.
Two things. Number one, is it possible that we can delay this a minute? I notice that there's several members, including members on the other side, that have not arrived yet. And when it does come time, I am going to ask to remove one person from the block.
Okay.
Thank you.
Do we need to wait? Anybody objecting to go ahead and, other than Senator Morrissey, to go ahead and, let me read this whole thing. The committee has taken up judges for, they've interviewed judges for the Circuit, District, and Juvenile Domestic Relations District Court vacancies. We interviewed them on February the 9th in a combined meeting of the House Courts of Justice Committee and the Senate Judiciary Committee. The list has been distributed. Please take a few minutes to look at it. And except for, I think Senator Morrissey wants to take one person out of the block. Otherwise, can we go ahead and certify these, except this one person? Okay, Senator Morrissey, you want to take out Kathleen Uston, Esquire, 18th Judicial Circuit from the block, is that right?
Yes, Mr. Chair.
Okay. Are you prepared to vote for the remainder?
Mr. Chairman?
Yes,
Is she the bar counsel?
Yes,
That's the one we're taking out of the block? It's, all right.
Well, we vote on her separately. We only have two Republicans here. Are we okay? Anybody objecting?
Is there objection?
Is anybody object? We only have two Republicans here. We do have a quorum.
Well,
Yeah, go ahead, Senator Robinson.
I don't object to considering the block. I mean, but I think if we're going to pull somebody out of the block to vote on her separately, I would hope that we would have a full contingent here for that.
Okay, we'll do that. Well, let's go ahead and vote on the block. All in favor of certifying the judicial candidates that are listed in the block, please say aye.
I'm going to call the roll, if I
Okay.
may.
Okay.
Senator Saslaw. Senator Norman. Senator Lucas. Senator Obenchain. Senator McDougal. Senator Stewart. Senator Stanley. Senator Deeds. Senator Peterson. Senator Servell. Senator McClellan. Senator Boysko. Senator Morrissey.
Aye.
Senator Peake. Mr. Chairman,
Aye.
I have 11-0.
11-0. All right. The block passes. We'll take up the separately the one candidate that's pulled out of the block when everybody's here. Okay. Now I'm announcing that House Bill 2331, Delegate Mullins' minimum mandatory bill, we'll put that off to Wednesday without objection. Senate House Bill 2331 of Delegate Mullen, which is a minimum mandatory bill. They're still working on this. We'll put that off till Wednesday, not today. Everybody understand? I'm also announcing that 5 bills are going to the subcommittee, Civil Law Subcommittee, and these are as follows. House Bill 2055 of Delegate Scott. That's 2055 of Delegate Scott. House Bill 2099 of Delegate Coyner. House Bill 2099 of Delegate Coyner. House Bill 2190 of Delegate Leftwich. That's 2190 of Delegate Leftwich. And 2193 of Delegate Leftwich. 2193 of Delegate Leftwich. And also House Bill 2319 of Delegate Guzman. 2319 of Delegate Guzman. They'll be put off tomorrow. It'll be tomorrow at 8 o'clock, Civil Law Subcommittee. That's Senator Peterson's subcommittee. Everybody understand that? 5 bills. House Bill 20, Senator Peterson? Okay, everybody understand? Okay.
If I may
Yeah.
name
Yeah,
the other
yeah,
members,
yeah.
Senator Lucas, Senator Norman, Senator Obenshain, Senator Boysko, Senator Servo, and the meeting is across the lobby in the East Room,
At 8 o'clock.
8 a.m. in the morning.
8 o'clock.
And, Mr. Chair, we may gavel in 10 minutes late because some of us are going to have to proxy in, because do we have Ed? No, we don't. Tuesday morning, what else is Tuesday morning?
It's Tuesday morning, it's Ed Sub.
Oh, never mind. Okay.
Okay.
Mr. Chairman,
Yeah, Senator Louise Lucas.
that's right, that's the name my parents gave me. Look, Mr. Chairman, I did not hear you call Leader Herring's bill. I know it's on your docket, but the Crime Commission does not have the expungement bill.
Right, that was to go by for the day.
Yeah, expungement's not on the calendar here today, I don't believe.
Yes, it's on the calendar, but the bill is not ready.
No, it's not ready. Expungement is,
So you need to put that off until Wednesday.
well, I'm not sure it's on the calendar.
Yeah,
Yes, it is.
It is?
yeah.
Okay, expungement, what's the number, expungement?
That's correct,
Chair,
2113.
the expungement bill is House Bill 2113. It is on the docket today.
Okay, that'll go back to today's expungement bill.
It needs to go by.
Yeah, that's not ready either. Okay.
Thank you.
Now, there's one bill that we passed, PBI'd last week, that I want to reconsider, and that's Delegate Guzman's bill, House Bill 2139, accrual of calls of action. And I'd ask somebody to move to bring back the bill, to reconsider the bill 2139 that was passed by indefinitely last week.
Mr. Chairman, having voted on the prevailing side, I move that we reconsider the vote.
Okay, is there a second? Second. All in favor of the motion, vote aye. No, we got to vote aye. Vote aye to reconsider.
Ayes 11, noes 1.
Okay. Now, I know Bob Hatton is interested in the bill, and he didn't get a chance to speak last time. The bill has now been in a position to be amended. Is there a motion? Would somebody explain the amendment to the bill?
Mr. Chairman,
Yes,
the substitute is posted to LIS for your consideration. There are two changes that it makes. First, it takes out the language about disease-causing circumstances, which was provided a bit of confusion for the committee last time. And it also gets rid of the language about the diagnosis of a non-malignant substance-related latent injury or disease shall not accrue in action based on the subsequent diagnosis of a malignant substance-related latent injury or disease.
okay. Did anybody have it in front of you? I guess it's on LIS. I think the bill fixes the problem with the bill. Senator Norman?
Two things, Mr. Chairman. One, who is offering the amendment? Secondly, the patron is not before us. And third, we got enough to do with that reconsidering bills and rewriting them and rewriting them and rewriting them, Mr. Chairman.
This should be easy to fix, I believe.
That's perhaps one opinion.
Okay. Is Delegate Guzman?
Mr. Chair.
Of course, yeah, Senator Obenshain.
Just one other thing, and I probably am going to support this bill, but we're putting it back on the docket. It was something that attracted significant attention. There was a lot of opposition. I don't know whether the opponents received notice that it was going back on the docket, and whether they've been given an opportunity to express their views about an amended or a substitute bill. And just process-wise, I'm concerned about, they're not in the room, they're not here, and about them not having an opportunity to be heard.
I think we frequently reconsider bills.
Usually at the same meeting.
No, next we can do it the next.
I know you
next
can.
time. We do, and that's what we're doing. Okay, does anybody want to make a motion to adopt the amendment? I can't hear.
Boysko, move to adopt the amendment.
Okay. It's been moved and seconded that we adopt the amendment. All in favor of the motion say aye. Aye. All opposed, no. Okay, now, Delegate Guzman may not be here. Is Mr. Hatton here? Bob Hatton. I think he wanted to say something. Is he here?
He's checking.
Okay.
Mr. Chairman, Sorovel.
Yeah,
real quick.
Senator Sorrell.
I just want to make sure we're on the same page. We're really talking about an amendment in the nature of a substitute and not an amendment, right?
Creston, this is amendment in the nature of a substitute? I think it
Yes,
is.
sir, Mr.
That's right.
Chairman.
Thank you.
That's right.
Mr. Chair, Robert Hatton is now in the Zoom room.
Okay. Mr. Hatton, welcome.
Thank you very much, Chairman Edwards. Am I on the?
Yes.
Oh,
Yeah, you're on the, we're hearing you. And
thank you very much.
yeah,
I
thank
appreciate
you.
this opportunity. The Virginia courts have ruled that the statute of limitations for latent disease claims, claims like cancer, black lung, and those types of things, with the exception of asbestos claims, begin to run when the damage, however slight or unknown to the victim, occurs in his body, long before the occurrence of symptoms or a diagnosis from a physician. This arose in the case of Locke versus Johns Manville. It was obviously recognized to be unfair at that time, and 4 years later, the asbestos exception to this rule was written by the General Assembly and passed unanimously. But for all other cancers, all other types of latent injuries, the Locke case remains the law. And this creates, in the words of the Fourth Circuit Court of Appeals, which decided a case just this past year called Adams versus American Optical, it creates a catch-22 situation for cancers and chronic illnesses that are caused by toxic substances or products. If the claim is filed before symptoms or a diagnosis occur, it will be dismissed for lack of proof. And if the claimant awaits the time that he has symptoms or a diagnosis, it will be deemed too late and dismissed under the statute of limitations. As a consequence, there is no remedy under Virginia law for these types of cases. And that's why the Fourth Circuit Court of Appeals called this statute of limitation for latent diseases manifestly unfair. Those are the words of the court. And the catch-22 analogy was the analogy of the court. And the court said that Virginia's statute of limitations essentially gives guilty corporations who create these carcinogenic risks a get-out-of-jail-free card. The law in 45 out of 50 states provides a discovery rule for these types of diseases. That's also the law of admiralty. It's the law of Federal Employee Liability Act. And what we ask in 2139 is for Virginia's law to simply be consistent with the vast majority of states who recognize the fairness of waiting for a diagnosis from a physician before starting the statute of limitations for claims based upon latent diseases. My partner, Aaron Jewell, is also, I understand, on the docket, and she will give you a list of the various types of products and damages that Virginia citizens receive today and have no remedy because of this Locke decision. So with your permission, if you could call on my partner, Erin, she would give you some examples of how this works in the real world.
Mr. Chairman.
Yeah, Senator Norman.
I know Mr. Hatton well, and at the end of the day, I'll support the bill, but process-wise, this stinks.
Okay.
Number one, you're giving them unlimited time to advocate an amendment in the nature of the substitute. Secondly, it was not on the calendar. And thirdly, those who oppose it have not had an opportunity to be heard. And I just think process-wise, it's not appropriate.
Okay, thank you. Aaron Jewell, go ahead.
Yes, thank you, Mr. Chairman and members of the committee. This bill corrects a long-standing gap in Virginia law that denied justice to those injured by toxic substances and products who have never presented symptoms or had a diagnosis. For example, a child with lead poisoning from toys imported with China coated in lead paint who later develops brain damage as a result of lead poisoning. A grandmother who uses talc for over 40 years on herself, her children, and later diagnosed with ovarian cancer, having no idea that her long-term talc exposure caused that cancer. The veteran who deploys from a Virginia base and suffers loss from a defective combat earplug, he can't bring a claim because Virginia law governs his claim, when a service member deploying from another state like Maryland could. The coal miner, the gentleman who is the subject of the Fourth Circuit Court of Appeals claims that my law partner Bobby Hatton mentioned, that gentleman can't bring his case against the manufacturer of a defective respirator that failed to protect him from black lung disease, the very thing the respirator was designed to protect him from. The shipyard worker diagnosed with multiple myeloma from repeated long-term exposure to benzene over the course of a 40-year career, who if he lived in almost any other state would be able to pursue a claim. Or the father diagnosed with prostate cancer from long-term use of Zantac to control his acid reflux. None of these individuals knew that their long-term use of a product would cause a latent disease or a terminal cancer. For these reasons,
let her finish. Go ahead.
for these reasons, we very much hope that this committee, that it is the will of the committee to support this bill, and I thank you for your time.
Okay, thank you. Anybody have any questions? Is there anybody else in supporting the bill? Anybody against the bill?
Mr. Chair, we have Mark Dix and Jeff Palmore to speak, I believe, in favor of the bill.
Okay, all right, Mark Dix, go ahead.
Well, if Mr. Palmore is going to speak in favor, I can let him go first. But good morning, Mr. Chair, members of the committee. Mark Dix on behalf of the Virginia Trial Lawyers Association. We support the bill. This law will bring us in conformity with most other states in the country. Thank you.
Okay, thank you. Mr. Palmore?
Hey, can I ask Mr. Dix a question?
Yeah, go ahead. Senator Obenchain.
Mark, are you there?
Mr. Chair, Senator Obenchain, yes, I am.
Yeah, I know that this substitute makes one change, and it removes the circumstance. Shouldn't the statute also run from the time that the plaintiff should have known through reasonable diligence about the cause of the injury? And doesn't this version not start then? I mean, isn't it an actual knowledge as opposed to when they should have known? And would you have a problem making that change, Mark?
Mr. Chairman, Senator Obenchain, I would actually defer to Mr. Hatton because he is more familiar with this particular area of the law than I am. I think I'd be out of my depth answering that question.
Go ahead, Ms. Hatton. Go ahead, Ms. Hatton.
Yes, sir. These involve the diagnosis of, primarily the diagnosis of cancer. It's a disease. These diseases can't be self-diagnosed. People frequently think they're just getting old or they're having symptoms that can't be explained. And so because the actual injury requires a diagnosis of a physician, you can't say that.
You misunderstand my question. My question relates to not the sickness, but the cause. When the plaintiff should have, through reasonable diligence, known of the cause of the injury. Shouldn't it run from that time as opposed to just creating an open-ended statute for a plaintiff to say, but I didn't know, and then having it become a test of credibility as to whether he actually knew or didn't actually know? I think usually the statutes dealing with discovery rules arise, the cause of action arises when they, through the exercise of reasonable diligence, should have known.
Well, Senator Obenchain, if you look at line 33, it says it's undiagnosable during the period of limitations.
Mr. Chairman.
Mr. Patton?
Mr. Chairman, we're having a running debate here.
Mr. Hatton, go ahead. Senator Obenchain. Okay, Mr. Hatton's got the floor.
I know you're for it, Mr. Chairman, but come on.
Mr. Chairman.
Go ahead. Mr. Hatton, go ahead.
You have to have medical proof of a diagnosis in order to sustain the cause. If I think, and I get people call me all the time and say, I think I have asbestosis. Well, they don't have asbestosis. They smoke too many cigarettes. And until that person gets a diagnosis of asbestosis, it's not admissible information in a court. And these are complex diagnoses that require a pathologist or a clinician to make, and knowledge of the symptoms does not provide you with any proof whatsoever.
Okay, thank you. Now, Mr.
And
Palmore.
I thank you, but that wasn't my question,
Okay.
Mr. Hatton.
Mr.
I
Chairman.
appreciate it.
Yeah, Senator Norman, yes, go ahead. I've heard you.
This process stinks, and I move the bill be passed by for the day so that those who have a different perspective have the opportunity to at least share it with us. Not going to change my vote, but this is not appropriate.
Second.
Okay, Mr. Palmore, let's let them, we're not ready for that. Mr. Palmore, would you like to say something?
Mr. Chairman,
Chairman, you have a motion on the floor.
I'm the chairman, okay?
You have
Mr.
a motion on the
Palmore's on the
floor.
floor. Mr.
There's a
Palmore
motion on
has
the floor.
something.
there is a motion that has
On the
been
floor.
made and seconded, Mr. Chairman, and you do not have the unilateral authority to ignore it.
There's Mr. Palmore had something to say. He was going to say something, I think.
There is a motion
Quickly,
on the floor, Mr.
Quickly,
Chairman.
Mr. Palmore, would you like to say something or not?
Mr. Chairman, I'd like to speak at the appropriate time.
Okay, all right. Okay, there's a motion to pass it by to when?
Wednesday.
Pass it by to Wednesday. All right, there's a second. All in favor of the motion to pass it by to Wednesday, say aye.
Aye.
All opposed, no. No, okay. We could have gotten rid of this bill very quickly, but thank you very much. It will be passed by till Wednesday, okay? All right, thank you very much, and I hate to ask everybody to come back, but please come back for this bill.
Mr. Chairman?
Yep. Senate Bill 2139 will be passed by till Wednesday. Yes.
Thank you, Mr. Chairman. Mr. Chairman, obviously there's going to be more consideration and discussion about this. Some of the folk on the other side, if they can share with the other members their views prior to Wednesday so that we can all have for lack of a more artful phrase, a full picture of the pros and cons of this bill.
Okay.
That would be helpful.
All right, thank you very much. All right, next bill is House Bill 1809. We're going down the list, and this is Delegate Kilgore's bill, suspension or modification of sentence.
Yes, Mr. Chairman,
1806. Yeah, Delegate Kilgore.
Good morning, Mr. Chairman and members of the committee. House Bill 1806 is a bill which will satisfy and solve an issue that practitioners often find themselves in who do criminal defense, that a lot of times a person is a petition to modify a sentence is filed with the circuit court, and then between that time there is a transfer to the Department of Corrections, and the court could lose jurisdiction. What this bill does to address that, it says that if a motion to suspend or modify a person's sentence is filed with the court that heard the case at any time before that person is transferred to DOC, the court could enter an order to retain jurisdiction for up to 60 days to address that motion or modification. And that's simply the bill, Mr. Chairman and members of the committee.
Okay, anybody have any questions of the
Mr. Chair.
Yeah, Senator Deeds.
My concern, Delegate Kilgore, is that the bill as drafted kind of leaves it open for action at any time. It doesn't have a time frame. How would you feel like on line 69 if we had a motion, or if we had an amendment at any time before the person is transferred to the department, if we inserted or within 60 days of such transfer?
Oh, I don't have any problem with that, Senator Deeds.
I'm just concerned about leaving an indefinite time frame in this bill.
Mr. Chairman.
I understand. I understand.
Okay. Would you have a motion?
I would move that amendment after at any time before the person is transferred to the department, after that insert or within 60 days of such transfer.
What line are you on?
Line 69. And then on line 71 through 77, you probably have to delete that language.
Mr. Chairman.
Senator Sherville.
Mr. Chairman, I don't have necessarily a problem with that idea, but I also kind of think maybe there ought to be an overall time frame, say like within 12 months of when the sentencing order is entered, or within 60 days of transfer, whichever is longer. Because sometimes these things happen fast, sometimes they happen sometimes they take a while. I was curious what Senator Deeds thinks of that.
Sometimes, yeah, sometimes they do take a while. I mean, I know people.
You want to pass this by for the day to look at it again?
Mr. Chairman, Mr.
Yeah.
Chairman, it's Steve Benjamin.
Steve, yeah.
I would recommend that the bill be amended as Senator Deeds has suggested. That works perfectly.
Okay. Read the amendment so we all.
On line 69, after, at any time before the person is transferred to the department, you insert "or within 60 days of such transfer," and then you would delete the new language on line 71 through 77.
Okay.
Second.
Is there a motion moved and seconded that the line amendment be adopted on line 69 after at any time before the person is transferred to the department, and insert "or within 60 days of such transfer," and delete lines 71 through 77. Is that correct?
The new language on 71 through 77, yes.
All the new language from 71 to 77. All right. All right. Everybody understand the motion? All right. All in favor of the amendment, say aye. Aye. All opposed, no. Okay.
Move to report.
Been moved and seconded that the bill be reported as amended. All in favor of the motion, say aye.
Aye.
No, but vote. I'm sorry. All in favor of the to report as amended, vote aye.
Ayes 15, no zero.
Ayes 15, no zero. The bill is reported as amended.
Thank you, Mr. Chairman.
Yeah, thank you, Delegate Kilgore. House Bill 1852, Delegate Sullivan, Uniform Collaborative Law Act.
Thank you, Mr. Chairman. Good morning, Mr. Chairman, members of the committee. HB 1852 began life last session when I brought this bill. It never made its way over here because my chamber decided, the committee on my side decided it needed a little more study. So Chief Justice Lemons actually appointed a study committee to look at this over the course of the summer. It was chaired by Judge Fulton of the Norfolk Circuit Court, and despite the pandemic, met several times with a robust discussion on the bill. The bill is based on and codifies the Uniform Collaborative Law Act. So it comes to us from the Uniform Law Commission, and I know everyone on this committee knows the thorough and rigorous deliberative process that the Uniform Commission gives to bills like this. So I would suggest to the committee that it's been thoroughly vetted. It is supported by the Virginia Bar Association, the Virginia Family Law Coalition, and the Virginia Collaborative Professionals. Collaborative law is a form of ADR designed to keep litigants out of court. It's, of course, particularly relevant in the domestic relations context, and it is already widely practiced in Virginia. This is not a bill that establishes collaborative law. We have hundreds of practitioners practicing this around the Commonwealth. It's practiced in all 50 states, and the Collaborative Act has been, or the Uniform Act has been adopted. I think it's now in 20 states. So I offer this as a way simply to define the sort of rules the road to create a uniform way to practice collaborative law, both within Virginia, of course, any out-of-state lawyers who come here. I hope it'll be the pleasure of the body to report the bill, and I know there are several witnesses who want to talk a little further about it.
Any questions of the patron?
Mr. Chairman?
Yeah, Senator Morrissey.
I'm going to show my ignorance because I'm looking at the definition section, and I'm addressing this to the patron, and I learned at St. Michael's in the 5th grade, don't define a word by using that word, and I'm trying to determine what the phrase collaborative law means, and if the patron can just explain it to me, because in the definition section, it defines collaborative 5 times by using the word collaborative.
Mr. Chairman.
Senator, who's this?
Surville.
Senator Surville.
I would say it means divorce lawyers that don't like to litigate.
Okay. All right. The Delegate Sullivan.
Thank you, Mr. Chairman. Thank you, Mr. Chairman, and I appreciate the comments of Senator Surville, and I'll try to answer Senator Morrissey's question, and hasten to add that there are practitioners of collaborative law here to, I am not one, but who are here to help with any questions. Obviously, as its name implies, it is a form of dispute resolution that's different from the typical adversarial process and focuses on sharing of information, the kind more so than in a typical piece of litigation, to get families and particularly families with children to a better, less painful, quicker, cheaper result.
Now, Delegate Sullivan, isn't it defined elsewhere in the code, collaborative law?
I don't know that it's elsewhere in the code, Mr. Chairman.
Right. Okay.
But as I said, I'm gonna defer frankly to Ms. Kais, who practices this and has for over 20 years.
Okay. Speakers in favor of the bill. Who is it again?
I know Ms. Kais is in line.
Go ahead, Ms.
Karen Kais.
Karen Kais, are you there?
Yes. Yes, I am. Can you hear me?
Yes, go ahead. We can hear you. Thank you.
Yes, good morning. I'm a collaborative practitioner, family law attorney, and certified mediator. And I'm here on behalf of the Virginia Collaborative Professionals. We support this bill to respond to the question about what is collaborative law and what makes it unique. There's a collaborative participation agreement that is signed at the beginning of the process. It's signed by the parties. It's also signed by the lawyers, and that participation agreement is outlined in the Uniform Act. And the key elements are that there would be no litigation during the process, that the attorneys are disqualified from representing their clients in any related litigation, and that each client has a collaborative attorney during the process. Both attorneys are present with the clients in their meetings. There's an option to have a financial specialist, a divorce coach, other neutrals that participate, and it's interest-based and it's non-adversarial. So the key elements are the collaborative participation agreement, which outlines the roles of the professionals in the process, along with the informed consent requirements that make this available to the public, and to make sure that they're understanding the agreement that they are engaging in. I'm happy to answer further questions.
Okay. How many other
Mr. Chairman.
states have this? How many other states have this? Do you know?
I believe it's 22. There may be one state that's pending. So it's either 22 or 23 that have adopted the act, and it is practiced in all states, and it's even practiced internationally at this point.
Senator Morrissey.
Thank you. To the lady who just spoke, I'm looking at collaborative law process, a procedure intended to resolve a collaborative matter without intervention of a tribunal in which persons sign a collaborative law participation agreement and are represented by collaborative lawyers. Is this simply mean two lawyers sitting down and doing what they always do anyway, try to resolve the matter, informal discussions to bring the matter to fruition or resolution? Is that what it is? Or is it a form of mediation? Or is it a form of binding arbitration? What is it?
Okay. It's very, very different than what you're describing, in the sense that if you have two lawyers who sit down with their clients and try to settle a case, at any point, either of those lawyers may file for litigation. They may have already filed litigation. They could turn around and then file litigation. There is part of the participation agreement indicates that if either party chooses to file litigation, neither of those attorneys can represent their client in a litigation process. So that's one piece that makes it unique. It is unique from mediation in the sense that each of the parties has their lawyer present, but also that the attorneys are the people who are managing the process. There is not a neutral who is the manager of the process. As in a mediation, you have a neutral who's managing the process. And I think you asked a few other questions. Let me make sure that I'm answering. Tell me if there's something that I missed.
Senator Morrissey, do you have any other questions?
Thank you, Mr. Chair.
All right. Now, does anybody else have anything they'd like to say on the bill, supporting the bill? Anybody else?
Daniel Gray, please go ahead.
Thank you, Mr. Chairman, members of the committee. I am Dan Gray, Chair of the Virginia Family Law Coalition. I served on the study group that was convened by the Supreme Court. We endorse Delegate Sullivan's bill. Collaborative family law practice is something that is happening in Virginia, and the promulgation of standards of direction for the parties and the lawyer participants, just as with mediation and with arbitration, is warranted. We appreciate that Delegate Sullivan is carrying this bill and appreciate the opportunity to address the committee. Thank you.
Okay. Anybody else like to speak in favor of the bill? Anybody want to speak against the bill? Okay, is there a motion? Moved and seconded that the bill be reported. All in favor of the bill being reported, vote aye. All opposed, vote no.
Ayes 12, noes 3.
As 12, noes 3, the bill is reported. Yeah, thank you. Delegate Sullivan, you have another bill, House Bill 1853, Lawyers' Clients' Accounts. Go ahead.
I do. Thank you. Thank you, Mr. Chair. Mr. Chairman, members of the committee, HB 1853 is affectionately known as the IOLTA bill. It really has to do with increasing access to justice for indigent litigants in Virginia. This is a bill that's been around the General Assembly for many years. We've never been able to get it over the finish line. What it does is simply remove the prohibition currently in the law, which prohibits the Supreme Court from enacting a rule of court requiring lawyers to maintain their trust accounts in interest-bearing accounts. This, as I said, has been around for a while. It's been talked about for many, many years. I'm really pleased to report to the committee that there is widespread agreement among all the stakeholders. Most particularly, I know the Bankers Association is here to speak in favor of the bill. Let me make clear that the bill does not create mandatory IOLTA in Virginia. All it does is do away with the prohibition of the Supreme Court considering whether to do so. So if this bill were to pass, the Supreme Court would then have the option of going forward and considering through its normal processes, which we all know are thorough and actually take a while, whether to have mandatory IOLTA here in Virginia. It is the law in, I want to say, 45 other states. What it does, of course, is it creates a situation in which interest on lawyers' trust accounts is gathered together and given to legal aid in Virginia. So it creates a source of funding for legal aid that's non-general fund money. Absent this, of course, the money just sits in the bank and does not help indigent litigants in Virginia. So it's a worthy cause, and I hope the committee will report the bill.
Delegate Sullivan, what's the estimate as how much more money could be raised for legal aid?
Of course, that's going to, thank you, Mr. Chairman, that's going to depend upon interest rates, which are low right now, but I believe Mr. Braley will tell the committee when he speaks that even under current circumstances, it will increase the support for legal aid at between $500 and $1 million. And of course, as interest rates go up, the numbers go up. And I don't need to tell anyone on this committee that legal aid is woefully underfunded.
Okay.
So this is a great opportunity to change that.
Any questions of the patron?
Mr. Chairman.
Senator Norman.
I move to report.
Well, the people would like to speak, I believe. Anybody want to speak? Just,
Mr. Chairman, quick question.
Yes, Senator Morsi.
Delegate Sullivan, I received a letter from Mr. Braley, and it was very helpful. As I understand it, the gist of this bill is it requires an attorney to switch their current non-interest-bearing account to an interest-bearing account, correct?
Mr. Chairman, Senator Morrissey, I don't want to try to lawyer you here, but the bill will not accomplish that. The bill will allow the Supreme Court to accomplish that. Should the Supreme Court adopt such a rule, yes, lawyers would be required to put their trust accounts in interest-bearing accounts. The bank would then sweep that money. This does not create any great burden on lawyers. The banks.
One final question, Mr. Chair.
Senator Morsi.
Delegate Sullivan, the interest that is generated from the thousands of attorneys' accounts, that money, that collective amount would go where?
To the Virginia Legal Aid Society, headed by Mr. Braley.
Okay.
All right, thank you.
Anybody else, any more questions? Anybody would like to speak in favor of the bill briefly, very briefly?
Mr. Chairman, Steve Benjamin.
Yeah, we have a list right now.
Yeah, Steve Benjamin, go ahead.
Here is my concern. But first, I want everyone to understand that I spent probably the entirety of my career supporting indigent representation. And I am a great friend of the Legal Aid Society. However, what the bill does by repealing the prohibition is permit the Supreme Court to require that attorneys set up interest-bearing accounts. Trust accounts hold other people's money. So when a client comes to me and gives me, pays money into my trust account, it remains their money. And that means that with an interest-bearing trust account, other people's money is being used to raise interest, which is then paid to the Legal Aid Society. The Legal Aid Society does many wonderful things, including advocate on certain issues. The people whose money is being used to support the Legal Aid Society may not agree with the advocacy or the position that they take on issues. And I'm concerned about the obligation that would then be imposed on attorneys to advise clients of what their money is going to be used for, what positions it will be funding, and whether we will then be required to set up separate interest-bearing trust accounts or separate, I don't even know how you would work your way through this mishmash. But that's my concern about the requirement that attorneys have interest-bearing accounts.
Mr. Chairman.
Okay.
Mr. Chairman?
Senator Morsi, no,
Thank you.
Senator Morsi, go ahead.
Question for Mr. Benjamin. Mr. Benjamin, I understand your concern that 100 different clients in the attorney's escrow account are earning interest and they may not want that money to go to legal aid or they need to be notified. But isn't the default that the bank doesn't pay interest and the bank is actually the one that benefits by not paying that interest, irrespective of the fact that 1 or 2 or 3 clients may not want that money to go to the Legal Aid Society?
Steve Benjamin, go ahead.
Certainly the banks benefit by having money upon which they don't have to pay interest, no doubt about it.
Okay.
Mr. Chairman?
Yeah, Senator, Delegate Sullivan.
Just at least in partial response to Mr. Benjamin, I know Mr. Braley is prepared to talk about this. I should point out that this is actually happening now. What we have in Virginia is we do have IOLTA accounts that are interest-bearing. Lawyers can opt in now. They have the option, but it's not in Virginia right now. It's mandatory.
They have,
so
this is automatic
process. This is a process with which lawyers and the banks are quite familiar.
Okay.
And it will not create any kind of
all right.
administrative burden on any kind of
anybody else have any more things to say? Anybody from the public? Mr. Braley, you in favor of it? Yeah. Is that right? From the public? Anybody from the public?
Mark Dix, please go ahead.
Morning, Mr. Chair. Mark Dix on behalf of the Virginia Trial Lawyers Association. We support the bill. We think it's a great way to improve access to justice. Thank you.
Okay. Anybody else? From the public?
Matt Bruning, please unmute and go ahead.
Morning, Mr. Chairman, members of the committee. Matt Bruning with the Virginia Bankers Association. We appreciate the work that we do with Virginia Legal Services Corporation and Mark, and appreciate Delegate Sullivan bringing the bill this session.
Okay. Anybody else want to speak? Okay.
Mr. Chairman?
Go ahead, Mr. Braley, briefly.
Yeah, just to respond to Mr. Benjamin's comments. First of all, IOLTA accounts are pooled trust accounts made up of funds that are insufficient in amount or going to be held for an insufficient period of time to generate interest on behalf of that individual client. So the funds are pooled together in a pooled IOLTA trust account, therefore finally having enough in terms of amount or length of time held to generate interest. So there is no loss to the client. There is no loss to the attorney. The burden on the attorney is simply filling out a one-page form. And actually, it's all information. They only have to put in their law firm name, their account number, and fax it to their bank, and the account is switched. It's a very simple process. We've been administering it for 25 years. And with the cooperation of the banks, the trial lawyers, and the Virginia Bar Association, we think it'll be a very successful partnership.
All right. Thank you very much. Anybody else? Is there a motion?
Mr. Chair.
Yeah, who's this?
Peterson.
Senator Peterson.
And let me first of all say I spoke with Delegate Sullivan over the weekend, and legal aid is obviously, in my neck of the woods, done some great work, and I certainly support us supporting them. Having said that, I will tell you as a small firm owner, you know, all the money that goes into your trust account, you have to account for every penny of it. And, you know, if I talk to my chief financial officer, who also happens to be my spouse, she's got to go in every weekend and make sure those books balance down to the penny. And it's a lot of time. And frankly, not having interest on the trust account in a lot of ways makes the bookkeeping easier because, again, the money is the client's money. You keep it in temporarily, then you move it out. You don't have to account for this amount of money belongs to the bar, this amount of money belongs to legal aid, this amount of money belongs to us, this amount of money belongs to this client. When you have a trust account, the trust account is a top-line number. And then you divide it amongst the clients that have put the money into trust. So all the advocates that have testified how great this bill is, and it does have value, I don't think any of them actually keeps a trust account. I would like to see a system whereby if we are going to go forward, two things. One, I'd like to carve out smaller firms because the cost of administration, frankly, greatly outweighs the value. And secondly, give them an opt-out so I could write a check for $500 or however much and be done with it, rather than have to have my wife go in and spend 50 hours trying to balance the books. That's my biggest concern right now, and yes, I did speak with her before I made these comments. Thank you.
Okay. Anybody else have any comments?
Mr. Chairman?
Yes, Delegate Sullivan.
Yeah, if I could just briefly respond to Senator Peterson, I appreciate his comments. The very first thing I would say, Senator, is I would remind the body, we are not creating a system for mandatory ILTA through this bill. What we're doing is saying, Supreme Court, you're no longer prohibited from doing so. Now launch your process, at which time lawyers all across Virginia will have a chance to weigh in on any rules that the Supreme Court might want to propose, including presumably the concerns that Senator Peterson have raised. So the Supreme Court will have plenty of opportunity to take into account concerns of small firms or others who might be concerned about the administrative burden of this, which I believe will be proven to be minimal, if not non-existent.
Okay.
Mr. Chairman?
Yeah, anybody else?
Mr. Chairman?
I can't hear.
This is Mr.
Senator Stewart.
Thank you, Mr. Chairman. Mr. Chairman, to Mr. Benjamin's point, so now I will have to sit down with a client and explain that their retainer is in a trust account and that will bear interest and that interest will go to someone other than them. And that puts me in a very awkward position with my client, it appears to me. If they want to do this, and apparently the bankers support this, why do we have to involve lawyers? Why can't we craft a bill that allows the banks to do this pursuant to law and take the lawyers out of it so we don't have any responsibility for this or have any accountability for it, because that particularly concerns me. A trust account, we have a great fiduciary responsibility in that, and I see this as another trap. Besides the fact that I've got to have a discussion with my client, and they may not appreciate this.
Mr. Chair.
Mr. Chairman?
Right. Senator Deeds?
You know, both Senator Peterson and Senator Stewart raise interesting ideas, good ideas. You know, and there's nothing in here that prevents the court from developing a rule that allows us to have separate accounts, separate interest-bearing accounts for our clients. This is just about the Supreme Court's rule. This is not the final product. We aren't legislating the final product with this bill. We're just,
Any further discussion? Senator Stewart.
Chairman, but in response to Senator Deeds, I would much rather this body make a rule than the Supreme Court. because we have that ability to do that. And if this is the path that the General Assembly wants to go down, why don't we make our own rule versus passing that off to the Supreme Court? I'm happy to work with Delegate Sullivan if this is where you want to go, but we could do this and allow the banks to do it and take the responsibility off of the attorneys, which I think would be a good thing.
Okay, I understand. Mr.
Mr.
Braley
Chairman?
wants to say something further. Go ahead, briefly.
Mr. Chairman, first of all, there is no ethical duty on the part of the attorney to explain to their client that the funds that they are retaining for them are going into a pooled interest trust account. That is clearly settled under the rules of ethics. It doesn't have to be explained to the client. Now, it's the lawyer's duty, if they accept a large sum from their client or going to hold it for a long enough period of time, it's already their ethical duty to set up a separate interest-bearing trust account on behalf of that client. It's only in the situations where the amount is not sufficient or going to be held for a long enough period of time that it can go into an IOLTR pooled trust account.
Okay.
And therefore, it's not the client's property, any interest generated on it, and is not their income. Getting to Senator Peters's comments, there's really no extra burden on your financial administration at your law office. The bank computes the interest, issues a remittance report. It's very clear what the principal is, what was distributed from the account, and what interest was paid to the Legal Services Corporation of Virginia. There is
Okay.
no extra
All right.
burden for the attorney.
Thank you very much. Is there anybody else that needs to speak? Is there a motion on the bill?
Mr.
Yes. Yeah, go ahead.
Jeff Palmer, please unmute and go ahead.
Yeah, briefly, Jeff.
Mr. Chairman, Jeff Palmer on behalf of the Virginia Bar Association, we support the bill and support repeal of the prohibition of a Supreme Court
All right, thank you.
rule. Thank you.
Thank you. Anybody else want to speak? Is there a motion? Motion on the bill.
Mr. Chairman,
It's,
Stewart over here. Would
Senator
the
Stewart.
body consider taking this by for the day and let me work with Delegate Sullivan to see if there's another path? I think there are others who are interested in that
I
path.
guess we operate by motion.
Well, I'd move it go by for the day.
Second.
All right, all in favor of the motion to go by for the day, vote aye. Aye. All opposed, no. Motion carries. Delegate Sullivan, look forward to seeing you Wednesday. Okay.
Thank you, Mr.
Yeah. It's House Bill 1866, Delegate Delaney, Court-appointed special advocates.
Good morning. Am I with you all, Mr. Chairman?
Yep, we're with you. Go
All
ahead.
right, pleasure to be with you all, if albeit virtual. So yes, Mr. Chairman and committee, I have today, I have three bills with you today, but first we'll be doing 1866. This bill allows court-appointed special advocates, which many of you know as CASAs, to participate in family partnership meetings as defined by the Department of Social Services and on individualized education program teams, family assessments and planning teams, multidisciplinary teams relating to child abuse, and multidisciplinary child abuse response teams. This bill also allows them to share information verbally with such teams that is acquired by virtue of their appointments and not share that information any further than those meetings.
Okay, any questions? Okay. Anybody would like to speak for the bill?
Melissa O'Neill, please unmute and go ahead.
How many people do we have to speak for the bill? What's the number?
We have 4 speakers for the bill.
Okay, very briefly, please.
Hello, I'm Melissa O'Neill, and I am the State CASA Program Coordinator for the Department of Criminal Justice Services. And this is a DCJS-sponsored bill, and the administration supports the bill.
Okay.
If there's any questions, I'd be happy to answer.
Any questions? Okay, thank you. Next person, again,
Chuck Slump.
briefly.
Yes, Mr. Chairman. Chuck Slamp, Commonwealth Attorney for Wise County in the City of Norton. VACA supports this bill. As Commonwealth attorneys, we are responsible for the operation of the multidisciplinary team to prevent child abuse. Having CASA involved in that team will help make sure that we can protect children. It's a good bill. We ask you to support it.
Okay, thank you. Who else?
Thank you.
Again,
Hank
very
Green.
briefly. It's in good Bill's in good shape, I think. Go ahead.
Thank you, Mr. Chairman. I would just reiterate with the comments by Mr. Slemp.
Okay.
Thank you.
Good, thank you. Anybody else?
Jonathan Iglesias.
Who else? Is there anybody else, very briefly? Give your name and who you're... Okay, it's been moved and seconded that the bill be reported. All in favor of the motion, vote aye. All opposed, no. Motion carries. I believe. I believe.
Ayes 15, no 0.
Ayes 15, no 0. See, I was right. Okay, thank you all very much. The bill is reported 15 to 0. House Bill 1867, Delegate Delaney, you're up again.
Thank you, Mr. Chairman. So House Bill 1867, this bill removes the requirement that survivors of sexual abuse must report the incident to law enforcement within 120 hours. That's only 5 days in order to be eligible to receive reimbursement for medical expenses from the Criminal Injuries Compensation Fund. Under current law, only minors are exempt from this requirement, but requiring victims of sexual abuse to report their trauma within just 120 hours of the crime committed against them. It's known to re-traumatize victims, requiring victims of sexual abuse to discuss the nature of abuse with law enforcement so soon after they've experienced the trauma can lead to heightened traumatic responses such as anxiety, depression, post-traumatic stress disorder, and disassociation. So this simply removes that time requirement, giving those survivors a little more time before they may wish to seek assistance from the Criminal Injuries Compensation Fund. We were pleased to discover that the fund has determined that there would be no fiscal impact by removing this time burden.
Okay. Anybody, any questions of the patron? Anybody who'd like to speak for the bill?
Nate Green.
Briefly, how many people do we have?
At the moment, just Nate Green.
Okay, good.
Mr. Chairman, could I ask a question before?
Yeah, go ahead. Yeah, question
So
of the patron?
We're removing any time, so if somebody came back 25 years and was asking for assistance with, say, counseling, would this now have the Criminal Compensation Fund pay out for that?
Delegate.
Mr. Chairman, I would say that it would give them the opportunity to make that claim. Currently, we give this provision for child victims. So if someone's under the age of 18 and is a victim of assault, they would have that opportunity to come forward years later and seek use of the compensation fund. This would expand that simply for the cases of sexual assault to all individuals, because there are certainly times where, it could be years in the future that someone may need assistance and may seek the use of this funds. It could also be a situation where someone could discover 6 months later that they've contracted a disease and need antibiotics and may wish to seek access to the fund as well. So they would go through the process of seeking access to the fund. Obviously, there would be a process to that, but it would allow for that.
All right. Any other questions of the patron?
Mr. Chair, my reading of the bill is that this simply makes consistent the application of the Victims Fund for adult and children as victims of sexual abuse.
Okay.
That's all it does.
Any other comments? Any questions?
Mr. Chair?
Yeah, Senator Morsi.
Follow up on Senator Deed's comment. If that is the reason, then why not simply say in that last sentence of paragraph 3, the provisions of this subdivision shall not apply to claims involving a minor? In other words, delete everything after the words claims except for, and then just keep in a minor. I can foresee a situation where a child is a victim of a crime and for a myriad of reasons doesn't report it for more than 5 days, not just in cases of sexual abuse, but many other crimes. Say the child was simply assaulted or beaten and doesn't, for a lot of reasons, doesn't report it. To the patron, Delegate Delaney, first of all, thank you for reaching out to me over the weekend and sharing your thoughts. What do you think about that to address Senator Deed's concern?
So, Mr. Chairman and Senators, I would say...
Go ahead.
Thank you, Mr. Chairman. So I would say that, the bill does simply eliminate the distinction between child victims of sexual assault and adult victims of sexual assault. One question that we had in terms of how broad to make this is also functioning in the reality that there are limited funds within the criminal injuries compensation fund available. We debated, how to go forward with this and how broad we would be able to make this. And I think that the bill we have before you, I was pleased to find, did not have a fiscal impact. I would be concerned that broadening its scope any further may harm that. So I think, proceeding with the ability for anyone under the age of 18 or over the age of 18 to have the option to seek access to these funds by removing that 5-day reporting period, I think is a good start. And I think it's a worthy topic to continue to explore how to ensure that child victims have access to services in the future. But I would say to the chair and to the committee that, I think we've struck a good balance for this particular session to expand access to more individuals by eliminating that 5-day period.
Mr. Chairman.
Any further questions? Senator Morrissey, go ahead.
Delegate Delaney, isn't there already a safety valve on line 20, the words, unless the commission for good cause shows fines? Doesn't that cover the situation that you wish to address, allowing a matter involving sexual abuse that is reported 6 days or 6 months later? Can't the commission already compensate the victim because of that safety valve clause that was that's already a part of the law?
Delegate Delaney.
Thank you, Mr. Chairman. Thank you, Senator. I would say that does exist to give sort of a safety valve. However, I would say, and I believe have some testimony here from those who work with victims of sexual assault, that it is simply an additional and unnecessary added burden for someone who's already been through a trauma to now, see that on paper they don't qualify for these services, and in order to get them now have to go and explain themselves to make the case for why they waited to come forward. And I think that it's an unnecessary burden. It's a re-traumatizing burden that we have the opportunity to eliminate.
Okay, thank you.
Anybody from the public want to say anything? Do we have anybody in the room?
Nate Green, please go ahead.
Okay, how many people are in the room?
We have 3 who currently wish to speak.
Mr. Chair.
In favor, very briefly, quickly.
I would just ask
Senator
whether anybody's in the room who opposes it. So I don't know that there's a problem.
Is there anybody, the 3 are in favor, right? And how many, who are they? State your name and who you represent and what your position is, very briefly.
Nate Green, please go ahead.
Nathan Green, Commonwealth Attorney for the City of Williamsburg and James City County, speaking on behalf of VACA. VACA is in support of the bill.
Okay, second.
Jonathan Iglesias, please unmute and go ahead.
Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. Our 65 rape crisis centers and domestic violence shelters and advocates are in support of the bill.
Thank you. Next.
Patricia Webb, please unmute and go ahead.
I have no opinion on this bill. I'm sorry.
Okay. Anybody else want to speak in favor? Anybody want to speak against the bill?
At this time, there are no other hands raised.
Okay. Is there a motion?
Move to report.
Second.
Been moved and seconded that House Bill 1867 be reported. All in favor vote aye. All opposed vote no.
Ayes 15, no zero.
Ayes 15, no zero. The bill is reported. It's House Bill 1911. Delegate Hope.
Thank you, Mr. Chairman. Hope you can all hear me. House Bill 1911 would end the corroboration requirement for no-fault divorces. Virginia, Arkansas, and South Carolina are the only other states that require third-party corroboration for no-fault divorces. Most requirements for a third-party witness affidavit to obtain a no-fault divorce would normally be excluded under evidentiary rules. As you know, many of you practice in this area, you know that they must swear that the wife is not known to be pregnant from the marriage, when the witness, in fact, may not even know the wife. They must swear that the parties were married on a certain date, regardless of whether the witness even knew the parties at that time. They must swear that at least one of the parties was a bona fide resident and domiciliary of the Virginia for at least 6 months prior to suit, when the witness may not even personally know the party who is a Virginia resident. They also must have personal knowledge that the parties have not cohabitated since the date of separation. And of course, especially in a situation we're in now with COVID, it's impossible for a third party to even know this unless they've resided with one of the parties throughout the separation. And that the witness must have personal knowledge that it has either been a party's intention since that date to remain separate and apart permanently. And of course, it's impossible to know what another person's intentions have been for this extended period of time.
Okay.
I could go on, but this is a bill that you've seen before. I think that the changes that we've seen with the pandemic, there's now no opposition. As far as I know, the Bar Association, the Family Law Council, all in strong support of this bill, and I believe they're here to testify in favor of the bill.
Delegate Hope, I think there's an amendment to be proposed. I move the amendment. Is there a second? Yeah, explain the amendment. Kirsten, explain the amendment.
Yes, Mr. Chairman, I just posted the substitute you requested.
Okay.
The substitute would get rid of all of the things that the affidavit needs to state except for the grounds for divorce.
Okay.
So if you can pull up the substitute on line 72, it reinstates that there be an affidavit of one corroborating witness, but the only thing that needs to be contained in that affidavit is giving factual support to the grounds for divorce stated in the complaint or counterclaim.
Okay, yeah, a second.
The amendment is not released to us. We can't even see it.
Okay, all right. All right, the amendment.
Mr. Chairman, I just looked, it is on LIS now.
Okay, tell you what, why don't we do this? I'm of those that we defeated the bill last year, I believe, and I'm among those that think we do need some corroboration, even though we can fix the affidavit to make it simple. Why don't we pass this by temporarily so everybody has a chance to read the amendment, including Delegate Hope?
Do you see the amendment?
Yeah, it's my amendment. Yeah, I'm offering the amendment. Let's pass it by temporarily so everybody can read it. Delegate Hope, 1912, child support payments. Go ahead.
Yes, sir, Mr. Chairman. House Bill 1912 would end child support payment requirements on parents to Department of Social Services while their children are in the Department of Juvenile Justice's custody. Virginia law requires that DJJ apply for child support from parents of committed youth. House Bill 1912 would eliminate that requirement that DJJ apply for child support payments with social services and eliminate the requirement for DSS to enforce child support obligations against parents and families of incarcerated youth. The current law disproportionately impacts Black families and other people of color. Of the 613 parents incarcerated youth against whom support is assessed or collected, 412 or 67% are African American. Of the 134 of those parents, only 22% are white. So really, I mean, I know that there's a FIS involved in this, and so if you were to report favorably on the bill, it'd have to go to finance. It's in the House budget. The question for really, and I understand that this is really paying for operating costs, but in my view, this takes money disproportionately from very poor families. And so if we're going to pay for operating costs for DJJ, I think it should be something that's assessed to the general fund.
Okay, any questions of the delegate? Any questions of the patron?
Mr. Chairman.
Senator
McDougall.
McDougall.
Mr. Chairman, I heard the number 600. I thought the last I had heard that there were only 250 some individuals that were in the custody of Department of Juvenile Justice. So could we have somebody from the department indicate how many individuals are in their custody at this point?
Yeah. Anybody know? Delegate Hope?
I don't know how many they have currently.
Okay.
Mr. Chairman, is there anybody from the department?
Delegate Senator McDougall, anybody know the answer to that question? All right,
Mr. Chairman, let me ask it more directly. Is there anybody from the administration or Department of Juvenile Justice on the line?
Mr. Chair, there does not appear to be anyone online, or at least no one with their hand raised to speak.
Okay. Anybody want to speak one way or the other?
Last number I heard.
Mr. Chair.
Yeah, who's a Senator Morsi?
Thank you.
Last number I heard was 250.
Question for the patron, Mr. Chair.
Go ahead.
Delegate Hope, I understand and support the spirit of what you're trying to do. As a practical matter, this bill would not require the parent to pay any type of child support while the child is in Department of Social Services. How would that practically work? a parent is required to pay, say, $500 a month child support, and the child goes into Department of Social Services on a temporary basis in the month of June. Is there another order that's entered by a court, or does the parent take it upon himself to calculate, okay, child is in social services for 2 months, I just won't pay 2 months of child support?
Mr. Chairman, there might be someone here that can speak directly to how the process works, and I don't know what the amounts might be that they are billed for support during this time. And I don't know if that's what the gentleman's getting at. There might be someone here that can answer that directly, what the process is and how they're charged and whether it has to go through an order.
Is anybody in the hinterland in the room available to talk about this issue one way or the other, this bill, one way or the other?
Mr. Chair?
Yeah.
This is Valerie Slater. I am an attorney with I am the director of Rise for Youth and a member of the Activated People and the National Association for Color, NAACP. And what I would like to say is that this bill will eliminate the responsibility for parents to pay DSS when their child has been committed to DJJ's care. And this is not just the kids who are in Bonaire, the Juvenile Correctional Center, but once a child has been committed to DJJ's care, they may also end up in a secure facility of another type, not just the Bonaire Juvenile Correctional Center. So that number of children, it is encompassing all children who have been committed to the Department of Juvenile Justice. And it eliminates the responsibility for children who have been placed in DJJ's care to pay the state child support. It is not eliminating a child support order for one parent to another parent for the care of that child.
Mr. Chair?
Yes, Senator Morrissey.
To the person testifying now, in all due respect, that doesn't answer my question. Here's the situation. A juvenile court judge issues normally an order for child support. The scenario that I gave is $500 a month. That's an order. Then the child goes into DJJ. All right? My question is very simple. Does the parent on his own, if this law is passed, say, I don't have to pay $500 for the next 3 months, or is there some type of order that needs to be entered by the juvenile court? That's my question.
Mr. Chair, we have Barbara Lucina from the Department of Social Services.
Yeah. Go ahead. Department of Social Services, go ahead.
Good morning, Mr. Chairman and members of the committee. Barbara Lucina for the Department of Social Services in the role of Director of the Division of Child Support Enforcement. The question on the table is whether or not child support would be voluntarily paid to the Department of Juvenile Justice in these scenarios if the requirement goes away. A child support obligation that was in existence prior to juvenile justice involvement under current rules is assigned to juvenile justice during the time that there is that relationship in existence. If this change is made, that child support would still be due and owing. If paid, it would go to the custodial parent rather than the Department of Juvenile Justice.
Okay. Any other questions? Did that explain it? Yeah, Senator.
So if we're to pass,
Senator Moore, yeah. Go ahead.
So
Google.
if we were to pass this, if I was paying child support and my child is in the custody of DJJ, I'd still be required to pay child support, but the other parent would not have to pay that to the department during the time that they're incarcerated. Or in custody.
Yeah.
Is that accurate?
That's the answer? I think the answer is yes.
Yes.
Okay, thank you. Any other questions? All right, anybody else want to speak one way or the other on the bill from the public?
Amanda Silcox, please unmute and go ahead.
Mr. Chairman? Mr. Chairman?
Yeah, go ahead.
Stewart, can I ask a
Senator
question?
Stewart, yes, go ahead, Senator Stewart.
I don't know to whom this is directed, but if you're not divorced, but you have two parents living together and you have a child committed to juvenile justice, do you have to pay for their stay? Or is it
Yes,
just
and that,
you do?
Yes.
yes, and both parents are assessed and must pay the state.
Okay. Now, does somebody want to speak in favor of the bill, I believe?
Amanda Silcox, please unmute and go ahead.
Good morning, Mr. Chair. Amanda Silcox, also with Rise for Youth, just reiterating our support as well as our partners at the Commonwealth Institute for Fiscal Analysis and the Juvenile Law Center. Thank you.
Okay, thank you. Anybody else want to speak in favor of the bill?
Rob Poggenglass, please go ahead.
Yeah, very briefly. How many more people speak in favor?
We have one more speaker, Sandra Carrison.
Okay, well, go ahead. Next person.
Rob Poggenglass, please go ahead.
Rob Pogenglass, Legal Aid Justice Center. We strongly support the bill. Each year, the Department of Social Services collects about $300,000 from parents of incarcerated youth. We support returning this money to the families and the communities. Thank you.
Okay, Sandra Carrison from the State Executive Secretary's office. Sandra?
Good morning, Mr. Chairman, members of the committee. To go back to the questions before, and perhaps they've already been addressed, but my understanding of this section goes to the lines 80, 84, 85, where it speaks to establishing court orders and filing motions for show cause for failure to pay, that those would no longer apply in those instances where this exception is being established. So that was my understanding of what this bill was doing, going to the point of the court orders that were in place or were being established.
Does the Executive Secretary have a position on the bill?
The court has no position on the bill.
Okay, thank you. Anybody else want to speak on the bill, one way or the other? House Bill 1912. Is there a motion?
Mr. Chairman, Finance did ask for this bill.
Okay. It's been moved. Is there a second? Senator Dees moves. Anybody second it? It's been moved and seconded that the bill be reported and re-referred to Finance. All in favor of the motion, vote aye. All opposed, no.
Ayes 9, no 6.
Ayes 9, no 6. The bill is reported and re-referred to Finance. Delegate Hope. Okay, next one is Delegate Watts, House Bill 19.
Mr. Chairman?
Yes, go ahead.
I believe Delegate Hope's substitute for 1911 has been available for everybody to see on LIS at this time.
All right, anybody want to take a look at House Bill 1911? Anybody?
Mr. Chairman.
Everybody had a chance to read it, yeah.
May I speak to the substitute?
Yeah, go ahead.
Mr. Chairman, I appreciate you making this offer because it does most of what I'm asking for, but it still requires corroboration on grounds. And it would require that a third party actually be in someone else's home to observe that they are in fact living separately. So the whole reason for the bill is to get rid of that requirement. So you're still in a similar posture, although you are eliminating a bunch of other things that you have to attest to that you can't possibly have knowledge on. There's still remaining one that you'd have to attest to that you have knowledge that you actually can't have that knowledge.
Delegate Hope, there may be a fundamental difference here. Some of us believe that corroboration is necessary to avoid lies. When I was in law school, we used to kid about the fact that divorces were determined by the preponderance of the perjury. We all know that there's a lot of perjury going on, and it happens, and the reason for corroboration is to try to avoid that. And so therefore, some corroboration is necessary. That's my position. I won't vote for a bill that doesn't require some corroboration. And this is designed to make it simpler for everybody. But taking corroboration out, I think, is not going anywhere. And I think last year we dealt with this bill as well. And I think what we do last year, we put it off or something.
Mr. Chairman.
Senator who? Senator
Sorrell.
Sorrell, go ahead.
Thank you, Mr. Chairman. You know, divorce is probably about, I don't know, a quarter to a third of my practice. You know, this requirement dates from a time when people used to, before we had no-fault divorces, and people used to have to fake grounds to get divorced. They'd, you know, send somebody to a hotel room to take a picture with you with a woman to pretend like you were getting having an adulterous affair, or they would, you know, fake desertion or whatever. And the whole point of putting this in back then is because people used to have to lie. People used to try to lie to get divorced because it was so hard. And then no fault came around, I want to say in the early 80s, and that became a lot easier for people to prove, because all you have to show court is that you don't like each other and you haven't been living together for a while. But this corroboration requirement hung around. And, you know, this corroboration requirement, to have somebody say that, you know, I've been in their house every day and I haven't seen any of his stuff, or I haven't seen any of her stuff, that, no, there's no extra toothbrush in the bathroom, or the clothes aren't there. It's just silly. And it seems to me that if the person who's seeking the divorce signs the affidavit, that's subject to the penalty of perjury. It's enough for almost every other thing we do in our legal system. It's not clear to me why we have to have this special requirement for divorce that we don't have for almost anything else in the world anymore. So I think the bill is probably an idea whose time has come, and the COVID pandemic has really highlighted it, because we've told people don't go into somebody's house. And so it's, for the last 12 months, it's been almost impossible for anybody to find a corroborating witness because nobody's been able to go in your house.
Anybody else want to speak on the bill, one way or the other? I totally disagree, Senator Servo, I'm sorry.
I'll move your amendment.
Senator Obenshain, the amendment, okay. My amendment is
Mr. Chairman, excuse me, I'm sorry. I noticed a technical change that needs to be made in the substitute. Section 20-99 would need to be taken out of the substitute because there would still be some corroboration requirement, but that's a technical change.
Okay, is there a motion to adopt the technical amendment to the substitute? All in favor of the motion say aye. Aye. All opposed, no. Okay, then the substitute is before you. Is there a motion to adopt the substitute? Yeah, as Senator Obenshain has moved to adopt the substitute. All in favor say aye. Aye. All opposed, no. Okay, now the bill is before us as a substitute. It does require some corroboration, but it simplifies it. And
Mr. Chair?
Yes, Senator Peterson.
I'll move to report the substitute.
Is there a second?
Mr. Chair,
yeah.
We do have public comment.
Okay, public comments. Yeah, go ahead. Public comments.
Valerie LaHero, please unmute and go ahead.
Thank you. Valerie LaRue from the Virginia Poverty Law Center. Mr. Chair, members of the committee, I think Senator Servel's points are very well taken. You know, this is no fault divorce we're talking about. So in that situation, if the person filing the divorce doesn't have the agreement of the other spouse has 21 days in which to file a response and say, you know, no, they're not agreeing with that. So I think that as far as any need to have corroboration, we've got that from the other spouse. It's a legal fiction to have this corroboration requirement. In most cases, this is a situation where people have not been compatible for quite some time and have been living apart. You have the affidavit of the filing plaintiff that is taken under oath with a notary. There are thousands of people in Virginia who file divorce pro se each year, and this witness affidavit often hangs them up. And the reason for that is because it takes them a while sometimes to gather all the information that they need in order to file their divorce. They get the witness to sign this affidavit, which again, they can't really swear to, but are sort of doing so as a legal fiction or under hearsay. By the time they get all their things before the court, a lot of times the court decides that the witness affidavit has been signed too early in the process. and makes them go find that witness again and redo the witness affidavit and resubmit that to the court. And it makes it take a lot longer for those pro se litigants who are already, in circuit court, which is a difficult court for them to be in. Thank you.
Okay. Have you heard that 9 out of 10, I've heard this, 9 out of 10 separations are not mutual? And the defendant frequently has been served, doesn't respond, and therefore the plaintiff can say pretty much what they want to say. And
under the no-fault divorce rules, if there is a waiver of service, the defendant has to sign on the actual divorce decree stating that they have seen it. Mr. Chair, in my experience and my observation, I'm not sure that this is a concern.
So some of us disagree. Okay, is there anybody else who want to speak for the bill?
Daniel Gray,
the bill?
please.
How many people want to speak for the bill?
Mr. Gray and Mr. Palmer.
Okay,
Just
make it short. Okay.
Daniel Gray, please unmute and go ahead.
Yes, Mr. Chairman, members of the committee, Dan Gray again from the Virginia Family Law Coalition. We opposed this bill last year, but the facts have proven Delegate Hope to be remarkably prescient in his thinking on this. The fact of the pandemic has rendered it a health risk to have others come into your home and to observe the separation. So on that grounds, we were convinced to support the bill. And I understand the chairman's concerns about corroboration, but we don't necessarily know what the future holds. And to Senator Servell's point, I think the time is now to do away with this requirement. Okay. So we thank you.
Okay. Anybody else? One other person I think wants to.
Jeff Palmer, please go ahead.
Mr. Chairman, on behalf of the Virginia Bar Association, we support the bill as well for the reasons mentioned by Mr. Gray. We think this requirement is antiquated and it's time for it to go.
Anybody want to speak another way? All right. Does anybody else want to speak publicly? Okay. We have a motion to adopt the substitute as amended. Is that right? All in? Yeah. Motion to report. Senator Obenshain moves to report the substitute as amended. Huh? Okay. Who moves to report the substitute as amended?
The report.
Okay. It's been moved and seconded to report the substitute as amended. All in favor of the motion, vote aye. All opposed, no.
Ayes 10, noes 5.
10-5. The motion, the substitute as amended is reported.
Thank you, Mr. Chairman.
Okay, thank you. Delegate Watts, 1936 on robbery.
Thank you, Mr. Chairman, members of the committee. The bill before you addresses an interesting anomaly in our criminal code. In Chapter 4, Crimes Against Persons, it is the only article that has essentially just two sections, one robbery and one having to do with carjacking. Every other article has numerous definitions of the type of offense covered. But in the case of robbery, we haven't touched the robbery statute in 50 years, since 1978. And what the bill before you does is it gives guidance to the court from the legislature saying that no matter what the circumstances, we give you no further guidance than 5 years to life. And by defining then, as we have in other such crimes, various categories of robbery, I think we are dealing with a long-standing potential for injustice, but certainly uneven justice throughout the Commonwealth. Walking you through the bill, perhaps the most and important element of it is that, as I will be referring to serious bodily injury, we are using a most current definition of serious bodily injury, which was used in the DUI maiming statute in 2019. And that is bodily injury that involves substantial risk of death, extreme physical pain, protracted and obvious disfigurement, or protracted loss or impairment of the function of a bodily member, organ, or mental faculty, an ongoing disability. With that definition in mind, what HB 1936 does is it sets first looking at where serious bodily injury is involved or death of any person involved with the robbery is guilty of a Class 2 felony, which would be 20 to life.
Okay.
The second would be by using or displaying a firearm in a threatening manner. It would be 5 to 20, or a Class 3 felony. If the robbery involves using physical force not resulting in serious bodily injury, or by using or displaying a deadly weapon other than a firearm in a threatening manner, it would be a Class 5 felony, punishable 1 to 10. And finally, if the robbery involves a threat or intimidation not involving a deadly weapon, it would be a Class 6 felony, 1 to 5. The Sentencing Commission impact statement points out that the ranges that I have just indicated fall within the median prison sentences that have recently been given. And the final comment that I would draw the committee's attention to is that as you look at the Sentencing Commission report, it is notable that, again, within a range of 5 to life as the statute's currently drawn, in the most serious types of robbery, we see that the median prison sentence was only 7.4 years, even though it resulted in a life-threatening injury. Whereas in the lowest category, robbery not involving a deadly weapon, the median sentence is 4 years. And so that this discrepancy between a very serious situation and a relatively minor situation compared to actual permanent bodily injury is what this bill is designed to address, giving the courts better guidance from the legislature.
Delegate Watts, what is the origins of the bill? I mean, what prompted the bill?
What, in my own personal case, while it was carried last year, because what you see at the lower ranges are with a range of 5 to life, you're seeing heavy penalties going that, again, are part of the justice reform issues of falling heavily upon those who are not properly represented in court, who are on the economically low income scale, as well as there is a racial element. In my own situation, the reason why I got involved in it, in trying to work out a reasonable approach to compassionate parole last year and looking at all of the crimes that were involved, I realized that in several cases, the issue wasn't necessarily the crime, but it was the way in which the crime was defined, that it was impossible to be able to separate out really serious offenses from those that, for example, again, that I got involved with, geriatric parole, that you would say, yes, this was appropriate, where it wouldn't have been appropriate at the high end, and there was no way to make that distinction. And that's where I began looking at where the code was not giving adequate guidance. And as I pointed out at the beginning, it really stands out when you look at Chapter 4 and the harms against the persons.
Mr. Chairman.
Senator Morrissey, question of the patron.
First of all, I want to congratulate Delegate Watts, and I support this bill 100%. I supported it last year when I introduced it myself before it got killed in the House Crim Sub. I'm glad that they had an epiphany, collective epiphany, and it's now back before us.
Okay, Senator McDougall,
Thank you, Mr. Chairman. Mr. Chairman, I just have a fundamentally different view. When the current law is that if you commit robbery, that means that you go to an individual person and try to take something that they own. Current law says if you try to do it by strangulation, try to do it by suffocation, by striking or beating them, by other act of violence, or you put that person in fear with a firearm or another deadly weapon. Mr. Chairman, there's different ways you can look at criminal offenses, but we have focused on the actual offense, not the results of the offense. And so in this case, a person is trying to take something from you by an act of violence or a threat of violence. That is one that the court or jury should be able to sentence you to a higher penalty. Okay. I do not think it's less serious if you don't actually have the weapon, or if you go and use a knife and tell somebody that you're going to cut them if they don't give you something. That makes it less serious. Okay. So there is a fundamentally different view, and I hope that we would defeat this. And this is exactly the behavior we should be trying to prohibit, not trying to encourage.
Senator Obenshain, you have a question?
Well, I have a comment, and I think that Delegate Watts identified what she views as a problem, but the problem is one that existed in past years. Over the course of the past year, we've done two things. One, thanks to Senator Morrissey, we have eliminated jury sentencing and have said we trust judges. We trust the judges. And the problem that I think Delegate Watts identified is with juries. And if we're going to trust judges, we need to trust judges. Second is Senator Edwards' bill, in which he is seeking to do away with mandatory minimums. We are doing the opposite of what we've said we want to do in this bill. And I think that at a minimum, I agree with Senator McDougall, but I think at a minimum we ought to wait and see whether this problem is solved through the actions of Senator Morrissey and Senator Edwards.
Okay, I'd ask the clerk if is there anybody signed up to speak to this bill? Mary Ann?
Yes, sir. You have one person ready to speak, Michelle Woolley.
Okay, Ms. Woolley, I'd ask you to be brief.
I will be very brief. I'm Michelle Woolley. I'm Managing Director of Justice Forward Virginia, and we support the bill.
That's all, Mr. Chair.
Okay. I'd ask Senator Morrissey, is this exactly the same bill you introduced last year?
Yes.
Mr. Chairman.
Delegate Watts?
Thank you. If I could, I do apologize. I didn't look. I was aware of Senator Morrissey's fine work on this, but I didn't look at the bill. My impression was that one of the important things was a firm definition of serious bodily injury that was current as opposed to strangulation, et cetera, but really looking at the degree of force that would have been involved to create a debilitating disfigurement, protracted loss. So I know that that's an important part of really being able to work through this. But if I could also, Mr. Chairman, address two other points with the bill, that as at the lower end, as I referred to the class 6 and class 5 felonies, we are looking at in the lower at least 400. Over half of the cases are in that lower level of recent cases. These people have not been before a jury. Again, one of the problems is they have not been represented often by adequate counsel so that they don't have the kind of plea bargaining that may or may not have gone into the higher end cases. So that I don't think that the change in jury sentencing is going to change will be extremely minor in the bulk of the people who may be before the court on these charges. And then I would also indicate that that if you have a weapon, you intend to use it, so that the issue of if you don't have a weapon, you are not intending the level of injury that could occur if you have a deadly weapon or if you have a firearm, which allows you to do harm at a distance.
Yeah, go ahead.
So that this is where
Let Delegate Watts finish.
Well, that could.
Go ahead. Go ahead, Delegate Watts. You have the floor.
I'm sorry. I
Vivian,
realized that I was
I'm trying to help
perhaps interfering with something, so I just continued and I concluded. Basically, I would point out that again, the four categories are reflecting intent, whether or not you have a deadly weapon with you, whether you have a firearm, etc.
I'm trying to help you.
Senator Peterson's trying to help you.
Right.
Yes, thank you.
I'd like to report this bill. I think it makes sense.
Mr. Chairman, it's Steve Benjamin.
Wait just a minute. I think the staff has some comments they want to make.
Mr. Chairman, yes, it's Steve Benjamin. On line 7, I have 3 suggested amendments consistent with the patron's intent. On line 17, I suggest inserting the words as defined by Virginia Code Section 18.2-51.4. That is the definition of serious bodily injury that Delegate Watts has described. Secondly, on line 19, I believe that the patron intends that the firearm be an actual firearm. And I believe, but I have this question for the patron, that the scenario where someone has a finger in their pocket pretending to have a firearm, that she means for that to be the category of offense found on line 24. If that is correct, then I have 2 amendments that will achieve that goal.
Mr. Chairman, the intent on line 19 is using or displaying, so the intent was that you would actually see it.
All right. And I would suggest on line 19 that after the word firearm, you insert as defined by 18.2-308.2:2, and on line 24, after threat or intimidation, insert the clause or any other means.
Okay, is there a motion to adopt the substitute as recommended by Steve Benjamin? It's been moved. Moved and seconded to adopt the line amendments as described by Steve Benjamin. All in favor of the motion say aye. Aye. All opposed no. The motion carries.
Mr. Chairman, I'm sorry, I didn't want to interrupt the vote, but I would point out that on lines 10 and 11, that the line amendment that refers to 18.2-51.4 starts out this bill and applies to the entire bill.
That's correct.
So perhaps first line amendment was not needed.
That's correct. That's correct.
Can I move to eliminate the first line amendment?
Second. Wait a minute. The first line amendment, you mean the one we just passed?
Yes.
All right, Steve,
That's correct.
you have any comments, Steve?
That's correct.
Okay, all right. It's been moved and seconded. The first line amendment we just adopted be deleted. All in favor say aye. Aye. All opposed no. All right. What we just passed was the second line amendment, not the first one. Is that right, Steve?
Yes, there were 2 line amendments on 19 and on 24.
Okay. Well, now, what did we just do? We deleted the first line amendment.
Deleted the first line amendment because the bill already has the reference to the statutory definition.
So the only line amendment we adopted is which one?
On line 19, after the word firearm, insert as defined by, and then the code section.
Right.
And on line 24, after threat or intimidation, insert or any other means.
Okay.
Oh, Can I,
Wait, that's what we just did, is that right?
well, hold on.
Yes.
Hold on.
Yeah, well, Senator Peterson, what's your question?
Threat or intimidation or any other means. I mean, any other means could be all kinds of, it has to be something to do with violence. I'm not sure I agree with this last line amendment of any other means.
Steve, Benjamin?
Robbery requires that it be violence or threat of violence. Line 24 says who commits robbery. So that means it has to be an act of violence or a threat of violence.
Okay.
Adding the words or any other means, this committee also made the same amendment to Senator Morrissey's bill last session.
All right, fine.
Everybody understand that? Okay.
Mr. Chair, I move to report the bill as amended.
Is any been moved? Is there a second? Second to report the bill as amended. Does anybody else in the public want to say anything?
Michelle Woolley.
Okay, briefly. Go ahead. Hey, how many people from the public want to say something?
I misspoke. Michelle Woolley has already spoken. Nate Green, please go ahead.
Okay, Nate Green. Go ahead, Nate. Commonwealth attorneys in favor?
No, Your Honor.
Okay, against the bill.
Mr. Chairman, Nathan Green, Commonwealth Attorney for City of Williamsburg, James City County. VACA does not have an official position. We did just want to point out that this is a situation where we are now making a robbery with a knife in which you actually use the knife and cut somebody punished less than grand larceny. It's a more significant punishment to go into the lunchroom and steal somebody's wallet than it would be to put a knife to their throat.
Okay. Any questions about that? Okay.
Mr. Chairman.
Is there a motion? Is there a motion anybody else from the public? I just want to make sure anybody from the public has a chance to say something if they want to.
At this time, there are no other hands raised to speak.
Okay. Is there a motion?
Mr. Chair?
Yeah.
I just want to quickly address that one point by the Commonwealth's attorney. He mentioned using a knife and cutting the person. It would be less significant than grand larceny. If you rob somebody, you used a knife and you cut them, that would come under the language in point 1, line 17, and it would be classified as a class 2 felony.
Mr. Chair, he was talking
Senator
about holding
Obenshain.
a knife to their throat, not
I thought I
cutting
heard
them.
him say, and cut him.
Holding a knife to their throat.
Mr. Chairman,
Yes, Nate, go ahead. Nate Green.
not every cut, not every wounding would qualify as a serious bodily injury under this definition. You could stab someone. We have a situation where someone was shot. Now that's different because it would fall under the use of a firearm, but we had a situation where someone was shot and had a bullet lodged near their spine, and that was determined to not fit under the definition of serious bodily injury that's being used here. So it wasn't a mistake that I said cut. You could cut somebody, but not have it be a serious bodily injury. And so then it would fall into the class 5 felony with a maximum sentence of 10 years. Not every time that you send someone to the hospital have you done seriously bodily injury to them under this definition.
Mr. Chairman, there's a solution to that.
Senator Steve Benjamin.
If you wanted to include the display or the use of a deadly weapon, such as a knife, then on line 19, after the word firearm, insert or other deadly weapon.
Okay. Is there a motion to amend? Yeah, Delegate Watts.
If I could speak to the suggested amendment, by essentially collapsing 2 and 3 by display, you're losing that distinction that with a firearm you can afflict serious bodily injury or death at a distance, as opposed to, unless you're really good at a nunchuck, as opposed to other weaponry which has the victim may perceive a lesser force and a lesser intent than someone who is using a firearm who intends at a distance to stop the person. I do understand the problems of larceny, and we certainly have thought about that, all of us. And that's another bill that I think does perhaps need to be addressed.
Mr.
But
Chair.
with this bill,
Mr. Chair.
I would again refer to the Sentencing Commission, quote, median prison sentences in recent robbery cases are within the reduced statutory maximums proposed. So this is in line with where the sentencing has been.
Yeah, Senator Peterson.
Yes, for the third time, I'd like to move the report as amended, if I can get a second.
Second.
All right. Any discussion? All in favor of the motion to report the bill as amended, vote aye. All opposed, no.
Ayes 9, noes 6.
9-6, the bill is reported. Thank you, Delegate Watts.
Thank you, Mr. Chairman. And members
Now,
of the committee.
thank you. House Bill 1948, Delegate Levine.
Thank you, Mr. Chairman. HB 1948 is a bill that I call my Good Apples Bill because it codifies things that good apples in the police and other law enforcement do already. This bill began in special session last year. It's had some improvements since then. I've taken into the concerns of senators and also of VACA, Virginia Association of Commonwealth Attorneys. And I'd like to begin by amending the bill to address VACA's concerns. So I'd like to suggest 2 line amendments. One I know your council has, one actually they don't have. The one they have is to add in line 41 the word reprimand to make clear that the disciplinary action that includes dismissal, demotion, suspension, transfer, or suspension, reprimand, or transfer of the law enforcement officer, that's one of the disciplinary measures that can be included if a law enforcement officer does not cooperate with an investigation. That one's on LIS. Should I give you the second line amendment as well?
Yeah, go ahead.
Second line amendment is to add in line 35 after the word conduct, the word administrative. Again, a 1-word amendment, so that it would read, it should be the duty of all law enforcement officers to cooperate fully with persons lawfully assigned to conduct administrative investigations into wrongdoing. That's to clarify that obviously all law enforcement has Fifth Amendment rights, all Americans do. And in a criminal investigation, they would not have a duty to cooperate. The duty to cooperate is for administrative investigations. So I would ask that if someone could move those 2 line amendments, it'll be in the posture that I want to talk
Mr.
about.
Chair.
Senator, who's this?
Morrissey.
Senator Morrissey.
I'd move one motion collectively to amend it, add both of those line item amendments that Delegate Levine just mentioned.
Is there a second? All in favor of the motion, say aye.
Aye.
All opposed, no. All right, with 1 aye, the motion carries 1-0. Okay. All right, Delegate Levine, anybody have any questions?
Thank you, Mr. Chairman. Let me explain the bill if I could. This is the Good Apples bill. It does 3 things. 1, it says that law enforcement who witnesses another person suffering from serious bodily injury or a life-threatening condition shall render aid as circumstances objectively permit to such person. 2, if a law enforcement officer witnesses significant wrongdoing that's not of a merely technical or minimal nature, they are required to report that to their superior officer. And if not, the witness can face discipline. This part is really the heart of the bill and the most important part. It's the idea that public servants serve the public first. And if they see another officer commit criminal misconduct or engage in bias-based profiling, or even something like being drunk on the job, that the commanding officer would like to know what's going on, and that in a good police department, the law enforcement serves, the good apples serve the people first. And so report it.
Yeah, Senator, go ahead. Finish up, Levine. Go ahead, finish up.
And if not, they face discipline. And then the third part of it, also a very important part, adds to the definition of bias-based profiling, sexual orientation, and gender identity. Anyone who knows the Stonewall movement knows that Black transgendered women were at the heart of that because they were being profiled by police, abused by police, simply for being trans, for being gay. And when we passed this bias-based profiling back in 2020, sexual orientation and gender identity were excluded. This includes it and says you cannot do bias-based profiling on that basis either. So that's the three parts of the bill.
Senator Peterson. Senator Peterson. Senator Peterson?
Stewart.
Or Senator Stewart? Okay.
Yes, Mr. Chairman,
Sorry.
thank you. Mr. Chairman, I didn't get in there quick enough, but I wanted to ask Delegate Levine about paragraph D.
Yes.
And I understand with witnesses, and I agree with the witnesses, but if it is an officer charged with a criminal wrongdoing, you're compelling that officer to answer questions against the Fifth Amendment. How do we justify, would that not be unconstitutional? How do we justify that?
Delegate Levine.
Mr. Chairman, Senator Stewart, by adding the word administrative, which we just did, I believe I resolved your concerns. The only requirement is for administrative investigations. Anyone charged with criminal wrongdoing absolutely has their Fifth Amendment rights. And if you want me to spell that out more clearly in the bill, I can, but this relates to administrative, not criminal. I could even add the words except in criminal investigations if that helps the senator. But that was the reason we added the word administrative.
Thank you.
Mr. Chair.
Mr. Chairman.
Senator
Could
Stewart.
we have Mr. Benjamin comment on that? I just want to make sure we're not compelling a person against the Fifth Amendment. And a Delegate Levine may have fixed that, but I would like to hear Mr. Benjamin's take on that.
Okay, Senator Steve Benjamin.
No, it's just Steve. It's a good question. Because even though the investigation may be an administrative investigation, the answers could still be incriminating. But I think that your right to assert your Fifth Amendment right against self-incrimination would prevail over the statutory mandate.
Okay. Any other questions?
Yeah, Mr. Chair.
Yes, Senator Deeds.
I've got a question for Delegate Levine. I'm looking at the last section of the bill on lines 45 and 46. How will a law enforcement officer know a person's sexual orientation or gender identity simply by seeing them, observing them? I mean, I agree with the intent of the bill, but how will they know those things simply by observing the person?
Mr. Chairman, Senator Deeds, I would answer that the bill says real or perceived race, ethnicity, age, gender, sexual orientation, gender identity. For example, with regard to race, sometimes people's race are not clear. But if it's real or perceived, if an officer perceives someone to be of a certain race and then acts against them to bias-based profiling, we prohibit that. If an officer perceives someone to be transgender or gay, and obviously there's going to be sometimes very obvious, two people walking arm in arm. There are certain people dressed a certain way where one may think that they're trans, but it really doesn't matter whether it's real or perceived. That's actually part of the current bias-based profiling language. And I think it applies to really any characteristics, ethnicity, for example. One may not know someone's ethnicity, but certainly there are police who might express prejudice against a particular ethnicity. And if they believe someone is Puerto Rican and they're not Puerto Rican, but they don't like Puerto Ricans, and they say, let's go get that person. It doesn't matter whether the person actually is or isn't. If a police officer acts based on perceived bias and expresses that, let's go get that, choose your horrible pejorative. It doesn't matter whether the person's black or not. If someone thinks they're black and acts accordingly, that would be enough. So I think actually the current language of the code, real or perceived, addresses that.
Okay. I have a question, Delegate Levine, two questions really.
Yes, Mr. Chairman.
Isn't this something that the law enforcement agencies should handle internally? I mean, last year we passed a whole laundry list of conduct that the officer could be decertified for. And shouldn't this be done internally as opposed to spelling out in the code here?
Thank you, Mr. Chairman. The code actually specifies an internal resolution. What it says is that it will be disciplinary action, and it gives a wide range of possibilities of disciplinary action, everything from dismissal to, as I added in line 41, reprimand. So it is up to the police agency to render the appropriate discipline, whether severe or minor. The reason it's in the code, and let me be clear, it's in several police departments' contracts already. We're going to hear from the police chief of Alexandria, who will tell you that it's in their code already. But the point of it is, if it's a statewide requirement, it will be in training. And police officers will learn when they're trained that if they witness misconduct, if they witness serious misconduct or criminal activities, they are required to report it. And then all law enforcement throughout Virginia, no matter what locality they're in, whether they're sheriff or police, will know that it is the law that they have to report misconduct. And that prevents it from being, Alexandria requires it, but some other place doesn't. But in terms of the actual punishment meted out, one difference between this bill and the bill I introduced last year is that originally, I had a misdemeanor in the bill if you witness criminal conduct. That's been taken out. So all of the discipline is meted by the law enforcement agency itself, but it makes one standard throughout the Commonwealth to tell every law enforcement officer, you have to protect the public first before you protect your misconduct committing buddy.
Well, I guess my second question, and it's good to do the right thing. In fact, I passed the character education bill in 1999. They have good character, and this is kind of like a good character thing. This is what you ought to do, but shouldn't be any disciplinary action if you don't, unless it's something internally. But the other thing is, we have a Law Enforcement Officers Procedural Guarantee Act, Procedural Bill of Rights. Doesn't this conflict with that?
Mr. Chairman, I don't think so. And we have other people here who might be able to speak to that. But
Right, okay.
the reason I don't think so is because all it says basically is tell the truth, cooperate with an investigation, report misconduct. I don't see any render aid to someone who's dying. I don't see any conflict at all, sir.
Okay, is there anybody who speak in favor of the bill? Anybody out in the public would like to speak for? How many people are there that speak in favor of the bill?
We currently have 6 people who want to speak to the bill.
Okay, speak briefly. I tell you what, I'll give you 30 seconds. I'm not going to cut you out immediately, but I'm going to let you know after 30 seconds to wrap it up, okay?
V. Lamnick, please go ahead.
Good morning, Mr. Chairman, members of the committee. My name is V. Lamnick. I'm the Executive Director for Equality Virginia, and we support the bill. We know that LGBTQ people, especially LGBTQ people of color, are more likely to be victimized by discriminatory police practices. So this bill broadens the definition of bias-based profiling to include sexual orientation and gender identity, which would effectively ban discriminatory policing against LGBTQ Virginians. We appreciate your support for the bill.
Okay, thank you very much. Next.
Sean Winetta, please go ahead.
Thank you, Mr. Chair. Sean Winetta with the Humanization Project. We appreciate Delegate Levine bringing this bill forward. And also, in my day job, I actually train first responders and I train law enforcement in first aid, CPR, AD, things like that, Red Cross health and safety training programs. And we believe they should have a duty to respond and appreciate him codifying this now. Thank you.
Thank you. Next.
Nate Green, please go ahead.
Good morning, Nate Green, Commonwealth Attorney for the City of Williamsburg and James City County, here speaking on behalf of the Virginia Association of Commonwealth Attorneys. Mr. Chairman, we did take a look at this bill. We do not have an official position. I did speak with Delegate Levine about some of the Garrity and the compelling issues. It is my belief that the changes that he has made have cured any problems with that, but I'm happy to answer any questions about why I do think that.
Okay, next.
Dominique Martin, please go ahead.
Good afternoon, Mr. Chair, members of the committee. Dominique Martin, New Virginia Majority. One of the major themes when discussing long-lasting approaches to police reform is the need for change at the institutional level. We believe this bill addresses that by addressing organizational culture. The bill incentivizes a more accountable culture amongst law enforcement officers, as all officers are incentivized to ensure the department is operating at the highest professional standards at all times. And so institutional issues do not manifest over time. And so we believe this is a good mechanism to keep officers accountable to each other, and we hope you support it.
Okay, thank you. Next, is there somebody else?
Valerie Slater, please go ahead.
Valerie Slater, Executive Director of Rise for Youth, board member of the Activated People, and Political Action Committee member of the Virginia State Conference NAACP. And for the reasons you have already heard, we all support that bill.
Okay. Anybody else want to speak in favor of the bill?
Mr. Chairman, there's two more people I know on the line, but they don't see themselves in the room. Carissa Tafty and Michael Brown.
All right, briefly, who are they?
Carissa Tafty, the Commonwealth Attorney for Arlington, and Michael Brown, the Chief of the Alexandria Police.
Okay, the Arlington Commonwealth Attorney. Go ahead. Arlington Commonwealth Attorney.
Good morning. I'm sorry that my picture is not showing up. I am Carissa Degani Tafty, the Commonwealth Attorney for Arlington County and the City of Falls Church. And I've been given permission to speak also on behalf of Greg Underwood, the Commonwealth Attorney for the City of Norfolk, Amy Ashworth of Prince William County, Steve Descano of Fairfax County, and Brian Porter of the City of Alexandria. And I am pleased this morning to express our enthusiastic support of HB 1948.
Okay, thank you. Next.
Molly Voigt, please go ahead.
Thank you, Mr. Chair. I'll keep it very brief. Molly Voigt representing Giffords this morning, and we support the bill. Thank you.
Okay, thank you. Anybody else want to speak in favor of the bill? Anybody speak against the bill?
We have Chief Michael Brown. I know he's on the phone.
Chief Michael Brown, are you on? Go ahead. Chief Michael Brown, are you on?
He's on the phone. If someone could unmute him, please.
Michael Brown.
1 second. I think he's unmuted now.
Okay, Michael Brown.
Mr. Chair.
Yeah. What's your position?
Mr. Chairman, Mr. Chairman and members, Mike Brown, and the Chief of the Alexandria Police Department. We're in support of the bill. We believe that the amendments that were just adopted will get around the Garrity issues and take care of the First Amendment right issues for administrative action. It's a fair standard for law enforcement, and it's also adopted by the Commission of Accreditation for Law Enforcement Agencies. Thank you very much.
Mr. Chair.
Yeah, Senator Peterson.
I'll ask a question of the Chief. You could institute this policy right now for your own force, correct?
Actually, we already have that, sir.
Okay, thanks.
All right, Delegate Senator Morsi, did you want to say anything? All right, anybody else want to speak for or against the bill, one way or the other?
At this time, there are no other hands raised to speak.
Okay, well, I'll pray by motion.
Move to report.
All right, Delegate Senator Morsi moves to report. Is there a second? Okay, second, Senator Boysko. All right. All in favor of the bill as amended, vote aye. All opposed, no.
Ayes 6, noes 9.
6 to 9. The bill is not reported. Okay, thank you, Delegate Levine. Delegate Levine. And now Senator Delegate Murphy, 1992. House Bill 1992, having something to do with firearms.
It does, doesn't it? Thank you, Mr. Chairman and members of the committee. We have a substitute.
Okay.
Mr. Chair?
Yeah.
Okay. Can I just...
Yeah, Senator Peterson.
I have a substitute, and I've talked with Delegate Murphy about this, and I think it's hopefully going to clean up some of the issues we had on the floor about people losing their gun rights for misdemeanor violations and how we would go about giving what would effectively be an automatic restoration after a period of time. So I think that should all be reflected in the substitute.
Okay. Is there a motion to adopt the substitute?
Move to adopt the substitute.
Does everybody have it in front of them? Substitute, is that online?
Mr. Chairman, I'm posting it now, so it should be available shortly.
Okay.
Mr. Chair?
Yeah, Senator Peterson.
While he's posting it, let me just say that I listened pretty closely to the debate, and I've been on all sides of this issue. I voted for it. I voted against it. My biggest concern was people losing gun rights permanently for what would be a misdemeanor conviction, which to me flies in the face of the criminal justice reform that we've had for the past year. So the compromise I discussed with Delegate Murphy was, first of all, narrowing the class of intra-family violence that would lead to this disqualifying conviction. So it really just focuses on either spousal or intimate partner abuse and takes out all the stepdad and guardian and all that stuff. And then secondly, that while you would lose your gun rights if you're convicted of a domestic violence misdemeanor, it would be for a period of 3 years. It would not be permanently. And so I'm not saying 3 years is perfect, but at least it's a period of time that people can understand. And if they are convicted or plead to one of these offenses, they need to understand that will be one of the consequences. But I think that gives a little bit more measured response to what is a legitimate issue that Delegate Murphy has brought forward.
Mr. Chair.
Senator Morrissey.
Question for the Senator Peterson. Does the substitute from the delegate comport with the bill that we finally got out of the Senate that was sponsored by Senator Favola?
Well, we killed that. That was the bill we killed.
You killed it?
Yeah, it doesn't not. I mean, it takes that further in terms of protecting the defendant's rights.
Follow-up question.
All right, Senator Morrissey.
So Delegate Murphy's bill now comports with what Senator Favola wanted to get accomplished. Is that right?
If I might, Mr. Chair.
Senator Peterson.
Yes. This is not identical to Senator Favola's bill, which did not have the automatic restoration. Remember, she had more about going back to the Crime Commission. This has basically, it's a 3-year loss of gun rights if you're convicted of a misdemeanor involving domestic abuse for an intimate partner.
Okay. Any other questions? Everybody understand the substitute? Is there a motion to adopt Senator Peterson's substitute?
Move to adopt.
Second. All in favor of the substitute, vote aye. Aye. Opposed, no. Motion carries. So we have before us now House Bill 1992 as a substitute. Everybody understands it's narrowed the scope of it. 3 years is the maximum, and it defines household member more carefully, more limitedly. Anybody, I understand there are a bunch of people who want to speak in favor of the bill.
Mr. Chair, are we going to allow Delegate Murphy to present the bill?
Go ahead, Delegate Murphy. I think she already. Go ahead, Delegate Murphy. I'm sorry. Go ahead.
Chairman. I appreciate the work that has gone into getting this bill and the posture that is necessary for it to pass. I appreciate Senator Peterson's assistance, and I hope that it's the will of the committee to pass the bill.
Okay, thank you. This is similar to Senator Favola's bill, I believe, right? Now, I understand there are a bunch of people who would like to speak in favor of it. I've been told there are 11.
Mr. Chair,
yes,
if I
Senator
could.
Deeds.
It's similar to Senator Favola's bill, but this bill actually solves the problem.
Right.
I mean, right now under federal law, if you commit certain offenses, you lose your right to get have possessed a firearm, and you can't get them back.
Right.
But the reality is there aren't federal agents enforcing this law. This takes that step further and acknowledges that state law will mirror federal law, that offense of domestic violence will prohibit you from having a firearm, but it solves the problem in that it says you lose it for a period of 3 years.
Okay.
So that offers some certainty to the law.
Thank you.
Mr. Chairman.
Yeah, Senator Norman, go ahead.
Mr. Chairman, just a point of reference, because there are, I think you said 11 people who want to speak. Do these 11 individuals, are they familiar with the committee substitute that Senator Peterson offered? Or
well, we'll ask them. I'd like to just put your name and who you support, or who you're with, and do you support it. Keep it as quickly as possible, because we have 11 people, and I don't want anybody to go beyond 30 seconds. Please, go ahead. Go ahead.
DJ Spiker, please unmute and go ahead.
Mr. Spiker, go ahead.
Mr. Chairman, DJ Spiker, I'm not sure why we're speaking in support, but happy to address the issue quickly. While we do appreciate Senator Peterson and Delegate Murphy's amendments, we do have the underlying concern that this bill does not mirror federal law. Virginia definition of assault and battery is far broader than the definition at the federal level. We do have concerns, so while this is a significant improvement, we are still not mirroring it. So we do appreciate the efforts to bring us better in line, but we still have concerns. Thank you, sir.
Thank you. Next.
Would all those who would like to speak in favor of the bill please use the Zoom feature raise hand?
Don't feel like you have to.
Christine Payne, please go ahead.
Good morning, Mr. Chair, members of the committee. Christine Payne from James City County, and I'm speaking on behalf of the League of Women Voters of Virginia. Victims of domestic abuse, primarily women and children, are often tormented and isolated by their abusers. This bill gives law enforcement the tools they need to disarm perpetrators of domestic violence. We support the bill.
Thank you.
Thank you.
Next.
David Mayer Sommer, please go ahead.
Next.
David Mayer Sommer, we can't hear you.
I'm sorry, can you hear me now?
Yeah, go ahead.
David Mayer Summer, Liberal Gun Club. We do not take an underlying position on the bill. Personally, I favor it, but this amendment addresses our concerns with regards to rights restoration.
Okay, thank you very much. Next.
Kelly Roskam, please go ahead.
Good morning. My name is Kelly Roskam. I'm with the Educational Fund to Stop Gun Violence. We strongly support the bill. It is true that this bill does not mirror federal law. In fact, federal law is much more expansive than the bill you are considering this morning. Federal law covers a larger number of offenses as well as a larger number of relationships. So we ask that you support this very important bill.
Thank you. Next.
Amber, please go ahead.
And my name is Amber Bomer. I'm with Moms Demand Action, and we fully support the passing of this bill. Thank you.
Thank you. Next.
Lori Haas, please go ahead.
Good morning, Mr. Chairman, members of the committee. My name is Lori Haas. I'm with the Coalition to Stop Gun Violence. We strongly support the bill. We appreciate the efforts of the members of the committee, Senator Peterson in particular, and Delegate Murphy for working on this bill and getting it into a posture that can pass. Thank you.
Thank you. Next.
Do we have any other speakers who wish to speak in support of the bill? Andrew Goddard, please go ahead.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We supported the underlying bill before the amendment, and I think the amendment probably doesn't do as much harm as it could possibly do. So we'll stay with supporting the amendment. Thank you.
Thank you. Next.
Tanya Shart, please go ahead.
Good morning, Mr. Chair, members of the committee. Tanya Sharp from the Brady Campaign to Prevent Gun Violence. We strongly support this bill. These expansions are key to protect those at risk of domestic violence and to keep guns out of the hands of those likely to harm others. Okay. We ask that you report this bill.
Thank you. Next.
Molly Voigt, please go ahead.
Thank you, Mr. Chair, members of the committee. I'm representing Giffords again, and we support the bill. Thank you.
Thank you. Next. Anybody else?
Jonathan Iglesias, please go ahead.
Yes, good morning, Mr. Chair and members of the committee. Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We are very strong support of this bill and thank the delegate for bringing it forward.
Okay, thank you. Next, anybody else? Is this it? Okay.
No, we have a few more. Melanie Cornelise, please go ahead.
Go ahead.
Morning, Melanie Cornelise with Moms Demand Action and Everytown Survivor Network, and we strongly support this bill.
Thank you. Next.
Heather Foglio, please go ahead.
Heather Folio, also a volunteer with Moms Demand Action and a constituent of Senator Peterson's, and we strongly support this bill.
Thank you. Next. Is that it?
Is there anyone else who wishes to speak in favor of the bill? Please raise their hand in Zoom. Nate Green, please go ahead.
Nate Green.
Thank you, Mr. Chairman. Nathan Green, Commonwealth's attorney for the city of Williamsburg and James City County, speaking in that capacity, not speaking for VACA at this time. I am in support of the bill.
Okay, next. Anybody else?
I believe that's all that's want to speak for.
Anybody against the bill? Okay. Is anybody? Go ahead.
All that would speak against the bill, please raise their hand. Philip Van Cleef, please go ahead.
Okay, Phil Van Cleef. Go ahead.
Okay, Mr. Chairman, the bill would have a problem or two with actually doing what the intent is, which is to allow gun owners to get their rights back after a period of time. You know, we could be in support of the bill if that indeed is the case. The problem is, as it's been explained to me, you have to take away all the civil rights and then restore all the civil rights for the federal government to recognize the restoration and then give a person their gun rights back. It's a really bizarre thing, but leave it to the federal government.
Okay, thank you. I think it's 3 years according to the bill, the substitute. All right, anybody else want to speak in favor or against the bill? Is there a motion?
Mr. Chair.
Yeah, Senator Morsi.
I want to speak to the bill.
Okay, go ahead.
I first want to begin by thanking Senator Peterson. He's worked with the delegate to make changes that are somewhat substantive to to Senator Favola's. But with that said, here's the problem that I have with the bill. We are in a period now where we're engaging criminal justice reform. We're expanding a category where people cannot hold firearms. And every time we do this, we got to look to see who are we capturing. So you can mention domestic violence, but here's who we're capturing. The husband and wife get into an argument and wife pushes husband. No weapon, no injury, a push. The police are called. The police are responding to a domestic violence report, and they are going to make an arrest. And that woman is going to be arrested for simple assault. She's barred from holding a firearm for 3 years. Or if it's a wife-wife situation, the same thing. So because we're capturing people that I don't think we want to, and even though the bill is better, Senator Peterson, for those reasons, I'm going to vote against the bill.
Okay.
Mr. Chairman.
Yeah, Senator Boysko.
Thank you, Mr. Chairman. I want to thank Delegate Murphy for all of her hard work over many, many years on this issue to stand up against domestic violence and protect those who are at great risk in their own homes. I also want to thank Senator Peterson for making this bill palatable to many of us. This is something that's going to help people, and I look forward to making a motion when appropriate.
Okay, it may be appropriate now.
Move to report the bill.
Somebody
Mr.
else?
Chair.
Anybody else want to speak? Go ahead.
Mr. Chair, we still have 3 people who want to speak in opposition to the bill.
Okay, briefly. All right. I didn't know we had any more. Okay.
Patricia Webb, please go ahead.
Good morning, Patricia Webb, VCDL. I want to point out, in addition to what Mr. Van Cleve pointed out, that this bill, like Delegate Morrissey said, encompasses quite a bit more than a violent, harmful assault. It's a misdemeanor charge, and you're taking away someone's civil rights, the right to defend themselves over a misdemeanor charge, and that is just wrong.
Okay, next.
Vincent Smith, please go ahead.
Morning. I just wanted to express my support for the statements made by Mr. Van Cleve and Ms. Webb. I'd also like to point out that in the midst of a divorce, I once had a microwave thrown at me. At what point are we going to extend these types of legislation to encompass other inanimate objects, such as knives and microwaves?
Okay, thank you. Next, anybody else? Next.
Jonathan LaRue, please go ahead.
Hello, can you hear me?
Yeah, go ahead.
Hello.
Go ahead.
Okay, thank you. So actually, Vincent stole my thunder. I was just going to make the point. If we are going to be logically consistent with this, then we should also be prohibiting people from having things like bows and arrows or hunting knives or machetes or any of those types of things.
Okay.
We are taking away people's civil liberties from it. We need to have some sort of limiting principle to this, and this is a slippery slope.
Okay, thank you.
So
next. Next.
At this time, there are no other hands raised to speak.
Okay. Is there any discussion? Is there a motion? We have a motion.
I've made the motion to
Okay, so
report the bill.
Moved and seconded that to report and re-refer the substitute to finance. All in favor of the motion, vote aye. All opposed, no. Louise?
Ayes 7, no 7, 1 abstention.
Okay, 7-7 with 1 abstention. Okay, the bill failed 7-1. Okay, the next bill is House Bill 2064, Delegate Simon, recording of electronic documents.
Good morning, Senators. Good morning, Mr. Chairman.
Yeah, thank you, Delegate Simon.
I think this is, of the two that I've got today, this is the fairly easy one. What this bill does is it takes our 2011 Electronic Notary Act, which was in 2011 fairly state-of-the-art. We were really a leader in this category back then, and brings it up to speed for 2021. So it conforms the language and definitions to the current practice and sort of state-of-the-art best practices as far as remote online notarizations are concerned. It also deals with the recording of electronically notarized documents. We've had a problem, particularly in the real estate settlement industry and land records, with people executing documents and using a remote online notary. It's fully in compliance with Virginia's laws, and then the clerk's offices don't have any way to record them because they don't accept electronic recordation. So what this bill does about that problem is it says if you can print an electronically notarized document and then sign an affidavit, essentially saying it was notarized properly and electronically the way it was supposed to be done, then the clerk will be required to record both the underlying document and the affidavit that goes with it so that we can keep our folks recording things in the land records. This has been a collaborative process with all the stakeholders from the Virginia Land Title Association, the State Bar, the realtors and bankers and mortgage industry are all on board with the way this bill came out. And so I hope it'll be the pleasure of the committee to report the bill.
Okay, any discussion? Any questions? Anybody want to speak in favor of the bill? Anybody want to speak against the bill? Is there a motion?
Mr. Chair, we do
Okay.
have one person from the public who'd like to speak to the bill.
Okay, go ahead.
Chip Dix, please go ahead.
Mr. Chairman, Chip Dix on behalf of various different groups, Delegate Simon explained the bill. We support the bill and urge its passage.
Okay, thank you. Anybody against the bill? Is there a motion to report? As Senator Norman moves to report, and there's a second to report House Bill 2064. All in favor of the motion, vote aye. All opposed, no. The motion.
Ayes 15, no 0.
Ayes 15, no 0. The bill is reported. Thank you. House Bill 2081, Delegate Levine, polling places.
Thank you, Mr. Chairman. HB 2081 prohibits the possession or use of firearms inside polling places, counting centers, recount centers. There are exceptions for law enforcement, retired law enforcement, and people who live and work next door. But the purpose of this bill is to keep people from being intimidated by folks with arms. It would add to the prohibited area where we have 40 feet outside a polling place. It says you can't solicit, you can't, ask people to vote for your candidate 40 feet outside the building. It would also add a sign that says no firearms, and that would let people know that they inside won't be intimidated by someone with a firearm. Some polling places do already have these restrictions. Schools and churches are already prohibited by Virginia law, but this would make it consistent for anyone voting. There were a couple of Virginians actually that went to Pennsylvania when they were counting the ballots to try to intimidate people with firearms and were arrested there because they have that law there. We don't have that law here. And there's a lot of support for this measure. Thank you, Mr. Chairman.
Any questions of the patron?
Mr. Chairman.
Yes, Senator Peterson.
Oh, Surville.
I'm Surville.
Thank you, Mr.
You
Chairman.
look so much alike. Go ahead.
Yeah, we dress alike too, apparently.
Yeah, you do.
So, Mr. Chairman.
Wish you had this suit.
So, I would ask the patron this. So, I obviously, you can't bring a firearm on school property, so a lot of polling places are already covered by this. But it seems to me that if somebody is concealed carrying at I guess this would be a church or a community center, a non-school polling place, because that's really what we're talking about here. Courthouse, I guess, except you can't, most courthouses, you can't go inside with a gun, at least in Northern Virginia, you can't. Okay, but.
Go ahead.
So it's not clear to me how a concealed weapon necessarily be a threat. What would seem to me to be a threat would be an open carry. And I would think that, a couple guys standing with AR-15s across the street would be a lot more intimidating than somebody walking around with a gun in their pocket. And so it strikes me that the real problem here is sort of the open carry of firearm as opposed to the concealed carry. And I was curious like I said, I wouldn't want to see guys with AR-15s 100 feet away. I was curious what the patron's reaction was to that and whether that might be an alternate way to address this.
Mr. Chairman, Senator Surville,
yeah.
I actually looked originally at 100 feet away, and if the Senate wanted to amend it, I wouldn't oppose that. It's just that the idea was 40 feet was already used for solicitation, so the idea was to have a single standard. As regards open versus concealed carry, there is no, and I looked this up, there's no place in the Virginia Code that actually defines exactly what open carry means. And there's actually no place in the Virginia Code that I was able to find, or any lawyer was able to find, where open carry was prohibited, but concealed carry was allowed. And part of the problem with making that definition, and you know, lawyers could spend probably a long time trying to define the difference, is that you bump into someone, you feel their gun, right? Is that concealed carry? Is that open carry? I guess that's concealed. You know, someone puts their hand on their gun and flashes it for a moment. Is that open or is concealed? This would actually open a huge can of worms in Virginia law. Virginia law actually just makes it clear: no guns in schools, no guns in churches. That's the standard that's used, and so I use the existing standard rather than create a whole new one.
Okay, any, Senator Peterson?
Mr. Chairman?
Yeah, Senator Peterson had a question.
Let me just make a comment. I mean, most of the polling places, at least in my county, are either churches or schools, so they're already covered, so that's a non-issue. You do have some privately owned locations, such as Fraternal Lodge. I have an Elks Lodge in my district, which is a polling location. That's private property. And, you know, whether they have a rule against carrying or not carrying, I have no idea. But, you know, I just think, absent some type of articulated issue, at least in this state, you know, I think you could capture people that could have a concealed carry permit. They could have the concealed carry in their glove compartment or somehow it's securely stowed and be liable for breaking the law, even though they're not putting anybody in harm's way.
I understand that 12 people want to speak, and Senator Stewart wanted to say something?
Mr. Chairman,
And I would also point out, in line with what Senator Peterson's saying, you know, Virginia is a vast rural state, and people hunt with shotguns, and they leave those shotguns in the car, and they're unloaded, and they're not intending to intimidate or harass anyone or brandish those guns, but they're in the car, and technically they'd be guilty under this statute. So if this is going to go forward, I think we've got to carve those folks out, and the folks who legitimately have a firearm stowed in their car responsibly with no intent. Perhaps you should look at brandishing at a polling place or something, you know, versus the way it's framed.
Okay, there's several people. Go ahead, Delegate Levine.
Just briefly, you could absolutely keep a gun in your car. You can park, and you're 40 feet away. Most people don't park 40 feet away from a polling place, next to a polling place. You park, you leave your gun in the car, you vote, you come back, your gun's in the car. That's already allowed. Thank you, Mr. Chairman.
All right, 12 people want to speak. All in favor of wanting to speak, raise your hand and speak in favor, and then the people who want to speak against, that'd be fine too. First, in favor.
Scott Miles, please go ahead.
And keep it short.
Good morning, Senator Edwards, members of the committee. I'm Scott Miles here representing Attorney General Herring. He supports this bill. Thank you very much.
Thank you. Next.
Lori Haas, please go ahead.
Laurie House, go ahead.
Good morning, Mr. Chairman, members of the committee. We strongly support the bill. Delegate Levine has done a good job carefully crafting the language in the bill. It just takes it to the space inside the building within that 40 feet where other activities are prohibited, and then inside the polling place itself. Yes, this protection is necessary for those places that are not governed by the church or school or other prohibited places. We very much support the bill. Thank you.
Thank you. Next.
Christine Payne, please go ahead.
Morning, Mr. Chair, members of the committee. Christine Payne from League of Women Voters. We support this bill because firearms have been utilized to suppress the vote at polling locations, and voter intimidation has no place in our representative democracy. We strongly urge you to support this bill. Thank you.
Next.
Kelly Roskam, please go ahead.
Good morning. My name is Kelly Roskam. I'm with the Educational Fund to Stop Gun Violence. We strongly support this bill. We think it's an important measure to prevent the chilling of individuals exercising their rights in a democracy. It's also very narrowly tailored, and we urge you to support this bill.
Okay, next. Thank you.
Maureen, please go ahead.
Thank you, Mr. Chairman and members. I'm a Moms Demand Action volunteer and proud mom of a new voter. We strongly support this bill. Armed intimidation has no place in our democracy.
Thank you. Thank you. Next.
Andrew Goddard, please go ahead.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We support the bill, and I spend 15 hours every election inside a polling place, and I've seen people lose their minds inside there. I would like to know that they're not carrying a gun when they do that. Thank you.
Next.
David Meyer Sommer, please go ahead.
David Mayer Summer, Liberal Gun Club.
We do not take a position. We do like the idea of restricting the ability to intimidate voters. We have some concerns about how it's being done. If the goal is to prevent intimidation, I think that that should be the key, and it could be someone standing 100 feet away as opposed to just 40 feet. Concealed, as for concealed carry, concealed means concealed. That means that it is not observable to the casual viewer. If somebody is bumping into you and discovers a gun.
All right, thank you very much. Next.
Melanie Cornelius, please go ahead.
Moms to Men in Action and Everytown Survivor Network support this bill. Thank you.
Thank you. Next.
Dominique Martin, please go ahead.
Dominic Martin, New Virginia Majority. We support the bill for the previously stated reasons.
Thank you very much. Next.
Tanya Shard, please go ahead.
Good morning, Tanya Sharp from the Brady Campaign to Prevent Gun Violence. This bill is necessary to ensure that voters are protected and can vote safely and without intimidation or risk in the Commonwealth, and we strongly encourage the committee to report the bill.
Thank you. Next.
Is there anyone else who would like to speak in favor of the bill? Please raise their hand at this time.
All right, those against, raise your hand.
DJ Spiker, please go ahead.
Thank you, Mr. Chairman. DJ Spiker, National Rifle Association, as Senator Peterson has pointed out, concealed carry certainly does not apply to the intimidation that those in support are in favor of. This bill is unnecessary. Last year's SB 35 already gives them authority. And if you don't believe me, you can believe the September 2020 study from the Coalition to Stop Gun Violence that says Virginia has plenty of laws to apply, including brandishing, intimidation, and local authority to already put these things into place. This is unnecessary. At a minimum, there should be an exemption for concealed carry as intimidation doesn't apply. There are plenty of existing laws. Thank you.
Okay, thank you very much. Next.
Patricia Webb, please go ahead.
Good morning. Pat Webb with VCDL. We oppose this bill. As pointed out by one of the senators, if you want to do something to prevent intimidation, make it against the law to brandish at the polling station. You're not going to prevent people from breaking the law. If somebody wants to come into a polling place with a gun, whether it's against the law or not, they will still do it unless you put up metal detectors at every single polling place. Are you ready to foot that bill?
Thank you.
Thank
Okay,
you.
Thank you. Next.
Philip Van Cleve, please go ahead.
Yeah, Philip Van Cleve, President of VCDL. Yes, we, for the reasons DJ Spiker mentioned, we oppose this bill. Thank you.
Okay, thank you. Anybody else want to speak one way or the other?
Vincent Smith, please go ahead.
Okay.
I'd just like to address the flaw in Delegate Levine's logic. He says that there's no legal definition of concealed in Virginia. Well, then how come my concealed handgun permit issued by the state of Virginia says the word concealed handgun on it? So that I think there can be an exemption here for concealed handgun permit holders. I'd also like to point out that to say that this is to prevent intimidation, there are a large portion of this country who are intimidated by clowns, so much so that it has a name. It's called coulrophobia. So are you going to also outlaw clowns in polling places?
Okay. All right, thank you. Next.
At this time, there are no other speakers.
Okay, is there anybody from staff want to say anything?
Mr. Chairman. Mr. Chairman.
Yeah, who's this?
Stewart.
Yeah, Senator Stewart.
Thank you, Mr. Chairman. I would like to ask Mr. Benjamin a question. Line 19 through 20 says knowingly possess any firearm as defined in 18.2-30, 8.2:2 within 40 feet of any building or part thereof used as a polling place. And I'd like to ask Mr. Benjamin, under that definition in the bill, would that include a weapon as defined in 18.2-308 if it were responsibly locked in your car when you came, or actually when you came in and parked in the parking lot, if it was a weapon in your car would qualify under that?
The answer is yes. If you're parked within 40 feet of a polling place or any building being used as a polling place, you are in possession of a firearm even while it is locked within your car.
Mr. Chairman.
Yes, Senator.
Mr. Benjamin, isn't the parking lot a part thereof used as a polling place? So, in fact, anywhere in that parking lot you could be liable?
Steve Benjamin.
I don't know the legal answer to that, but I don't know the legal answer of whether a parking lot is considered part of any building.
Okay. All right.
Mr. Chairman?
Yeah, Senator Obenchain?
The polling precinct at which I vote has the 40-foot line that extends into the parking lot.
Okay. All right. Next. Anybody else want to say anything? Is
I
there,
do, Chairman.
go ahead. Is there a motion?
Mr. Chairman, before we vote,
Yeah.
Stephanie Isles of the Virginia Registrars Association has been trying to speak. And
Okay. All right. Speak. You go ahead. Speak.
I think
Mr. Chair, they're not in the room at the time.
She says she's.
Could they please raise their hand? As an attendee, could they raise their hand and we can move them in?
Okay.
On the phone. I can tell you that
Okay.
the Virginia
They're moving into the room now.
There she is. There she is. She's in the room. I see her.
Okay. Go ahead.
Stephanie Isles, please unmute.
Hi, good morning. Thank you so much. Stephanie Isles, I'm the Director of Elections and General Registrar for the City of Norfolk. Speaking on behalf of the Voter Registrars Association of Virginia, we do support uniform application of prohibited activities during Election Day. Many of our polling places, as previously mentioned, such as schools, community centers, libraries, and churches may already be covered under current statute. However, there are some private facilities that are used as polling places on Election Day, and this would make those uniforms so we could train all of our election officials the same and have the same laws in effect for all locations. Thank you.
Thank you very much. Is there a motion on the bill?
Mr. Chairman, may I just briefly?
Yeah, briefly. Go ahead.
Very briefly. First of all, I should note that many states have this law, including states like Mississippi, Louisiana, Georgia, Missouri, Ohio, South Carolina, Texas, Florida, Arizona, not all liberal states. Secondly, I would note that the 40-foot line is marked, and technically you'd be in violation if you're in your car and you're soliciting someone to vote some way, I guess. But the way this is enforced, and I think this is an important point that may, excuse me, allay some people's concerns. It's enforced in Section G, 45 to 47. A majority of the officers of election have to basically say you're in violation before you can be held in violation. That's why not everyone's carted off to jail when they accidentally walk across that 40-foot line.
Good. Thank you. Is there a motion to is there a motion? Been moved and seconded that the bill is amended. The bill be reported. Is there a second on that? Senator Deeds, seconds. All in favor of the motion to report the bill, vote aye. All opposed, vote no.
Ayes 8, no 6.
Ayes 8, no 6. The bill is reported. Thank you.
Thank you, Mr. Chairman, members of the committee.
Okay, the next bill is Senator Herring's bill on expungement. That'll be put off to Wednesday. They're still working on it, I understand. House Bill 2113 will be put off till next Wednesday. Okay? All right, moving forward, Delegate Rome, House Bill 2132.
Yes, Mr. Chairman, can you hear me?
Yes.
Thank you, Mr. Chairman. And Mr. Chairman, to the members of the committee, we worked extensively, and I just want to give a lot of gratitude and thanks to Council Steve Benjamin on a number of line amendments that we have for this. And so if it's the will of the committee, I'd like to move the amendments.
Okay. Is there a motion to adopt the line amendment? Yes, Senator Morrissey.
Mr. Chairman, first of all, I want to thank the delegate for reaching out to me and twice over the weekend on this bill. There are some, I think, substantive amendments that are not reflected in a bill yet. And it's important because this deals with mens rea scienter. Would the delegate have a problem, because we don't have a final bill yet, carrying this over to Wednesday so that we can review those substantive changes? And I mean no harm whatsoever to your bill, but I do want the body to get and review those substantive amendments.
Okay, without objection, House Bill 2132 of Delegate Romes will be put off to Wednesday afternoon.
Mr. Chair?
Yeah, Delegate Boysko.
Thank you. I would like to inquire if Delegate Rome has brought in witnesses that would not be able to testify at another time, just to try to be respectful of them.
Mr. Chairman, and to the senator's point, I actually do have a number of witnesses who are here to testify. I don't know what their availability schedules would be on Wednesday. If you would like to hear from them, I'm happy to do that. And if it's ultimately the will of the committee to pass by until Wednesday, I certainly will abide by the will.
Well, let's put it this way. We're going to put it by till Wednesday. If they are not going to be here Wednesday or can't for some reason, we'll be happy to hear them.
Okay. Then I guess the floor should be open to the public. Sure.
Well, let me know. Is anybody that? How many people are there that would like to speak?
We have 4 people currently raising their hands to speak.
Can any of them indicate whether they can not be here Wednesday afternoon?
Will those who
Mr. Chairman?
Yeah, Senator Morrissey.
Senator Boysko indicated to me there may be a witness who is unavailable on Wednesday.
Okay. Well, who is? That's what I'm trying to find out.
Maybe we could hear that witness.
Is there somebody that cannot be here Wednesday? We'll hear from them.
Would those who will not be available Wednesday for testimony please go ahead and speak? Or raise their hand, I'm sorry.
All right.
Mr. Chair, there are no hands raised.
Okay, that'll be good. We'll put it off. Go to Senator Boysko.
Ms. McClellan, before we go, my understanding is I'm not sure if it was a substitute or amendment, but they won't be released unless either they're offered or the chair tells DLS to release them online. So if we could at least get the amendments or substitute released so they will appear online today.
Yes. Can we go ahead and get the proposed substitute online so people can see it?
I'll post the amendments online.
Okay.
Mr. Chairman.
Senator Searle.
Thank you. Senator Boysko made a motion that I seconded that we adopt the substitute, which would put it online. I think we could take a quick voice vote and take care of that.
Okay. So would Charles explain the substitute briefly?
Mr. Chair, there are 7 line amendments.
Okay.
The 7 different line amendments basically strike out the notwithstanding provisions, insert in and of itself in several places of the bill, which basically just make it so that the proposed bill, it's limited to the application, meaning that can't be offered alone.
This is a clarifying amendment, right?
Correct.
There's a motion to adopt the line amendments. It's been seconded. Any discussion? All in favor of the motion say aye. Aye. All opposed, no. Okay, thank you. And we'll put off.
Mr. Chairman.
Mr. Chair.
Yes, go ahead.
We have one public testimony that wishes to be heard now.
Okay, go ahead.
Amy Ashworth, please unmute and go ahead.
Good morning, Senator Edwards and members of the committee. I am the Commonwealth Attorney for Prince William County and the cities of Manassas and Manassas Park. I've also been a defense attorney in my career. I worked with Delegate Rome on this bill. I come to speak today in favor of it. I've reviewed the amendments. I think they are appropriate. Primarily, this bill would make it more difficult to ask a jury or a judge to find that a victim's sexual orientation or their gender identity or expression is a reason to kill them or to injure them. And I think that's an important reason why we should support this bill. Thank you.
Thank you. All right. Anybody else cannot be here Wednesday? Okay.
Robin Anderson, please go ahead.
All right, go ahead.
Thank you. I'm a resident of Lake Ridge and a pastor of Commonwealth Baptist Church in Alexandria. I'm just here today to make sure that it's clear that I support this bill because of my faith. A central tenet of my faith is that every human being is worthy of dignity and justice. And just as Ms. Ashworth said, that in these panic defense bills, in these panic defense laws, a hate crime victim's very identity becomes both the reason for their murder and the exoneration for their murderer. And when violence against a human being can be excused because of their orientation or identity, our laws are unjust, and we're allowing people to be denied the dignity that others of us have and protection.
Thank you very much. Senator Morrissey, you want to withdraw your motion to pass it by to Wednesday? We've already heard 2 people. Okay, we have a motion to pass it by to Wednesday. Well, that's the question. There's a motion been made by Senator Morrissey. Is there a second to the motion? been seconded to pass it by to Wednesday. Okay, that's the motion. All in favor of the motion to pass it by to Wednesday, say aye. All opposed, no. I can't, go on the board. Call the roll. Who wants to pass it by to Wednesday? Vote aye. If not,
That's as specific as I can get.
okay, pass it by to Wednesday. Okay. All right, it will be passed by to Wednesday afternoon, and anybody else who would like to speak Wednesday can do so. The substitutes online. Okay?
Thank you, Mr. Chairman.
All right, thank you. All right, House Bill 2133, Delegate Delaney, writ of vacatur for victims of commercial sex trafficking. Delegate Delaney.
Hello, Mr. Chairman, and hello again, committee. So this bill was one of the Crime Commission recommendations, so it may be familiar to many of you. This bill establishes a process for sex trafficking victims to have criminal convictions for prostitution, solicitation of prostitution, and maintaining a body place vacated and removed from the criminal record. Virginia is one of 5 states that does not provide conviction relief for victims of sex trafficking. The Commonwealth's current sex trafficking laws reflect a misunderstanding of the convoluted dynamics within the commercial sex industry. Manipulation, coercion, deception, and intimidation are used by traffickers to force victims into committing illegal acts of prostitution. 41.6% of sex trafficking victims are indoctrinated as minors, and their previous abuse, trauma, drug dependence, unstable homes, and low self-esteem are exploited by their traffickers. What sex trafficking victims lack is criminal intent. The prevalent misconception that trafficking victims are criminals rather than victims of a predatory criminal enterprise has stymied our ability to adequately deal with the prevailing issue of sex trafficking in our state. This bill creates a pathway for victims to vacate their criminal records in connection to sex trafficking. And I do know that there is an amendment that council has prepared after consultation with the Crime Commission that would help better define the victim of sex trafficking. And if the chair perhaps would like the council to.
Yes, council, could you offer the line amendment?
Yes, Mr. Chair. I do have a couple of amendments, so if Delegate.
Okay, can you put them online? Yeah, I'm sorry.
We have one that the Crime Commission sent. There will be some testimony. There may be some question about ways to, if we want to handle juveniles involved differently, but I think, Mr. Chair, I would ask to start with the Crime Commission amendment that simply adds for money or its equivalent, and then the second line with individual with whom person engaged.
Okay.
So, Mr. Chair, there are 2 line amendments. The first one is on line 22, after the word intercourse, insert for money or its equivalent. And the second one is on line 22, after section 18.2, 346, insert by any person other than the individual with whom the person engaged in the acts of prostitution or unlawful sexual intercourse for such money or its equivalent.
Okay, is there motion to adopt the line amendment? Senator Deeds moves, and Senator Boysko seconds the line amendment. All in favor say aye. Aye. All opposed, no. The motion carries. The line amendments have been adopted. Okay, Delegate Delaney.
So, Mr. Chair, I think that explains the bill, that this would put us in alignment with, again, we're one of only 5 states who does not have this opportunity for victims of trafficking to have those records vacated. I know there are possibly a number of people or a few people that are here to speak.
Okay.
To the bill.
Who'd like to speak? Anybody have any questions of the patron? If not,
Mr. Chair.
Well, Senator Morrissey.
Actually, I'm going to withdraw that request, Mr.
Okay.
Chair.
Now, the people who want to speak in favor of it, how many are there?
Those who wish to speak in favor, please raise their hand in Zoom. We have 3 who wish to speak in favor.
Okay, 3. Okay, go ahead.
4 who wish to speak in favor.
Yeah.
Tom Intoriso, please go ahead.
Go ahead.
Thank you, Mr. Chairman. Members, my name is Tom Intoriso, and I'm an associate director with the Virginia Catholic Conference. We strongly support the bill. 26 states currently provide for vacator relief, and 13 states provide for expungements. This is a great bill. It addresses a growing problem in the Commonwealth. In October of 2018, the Human Trafficking Institute released a report in which Virginia ranks 6th in the nation for active human trafficking cases. And the Eastern District of Virginia ranked in the top 6 districts for criminal defendants in human trafficking cases. So I think everyone here is keenly aware of the problem, and this bill takes a very good step forward in helping to allow victims to.
Thank you very much. Next.
Sydney McCoy, please go ahead.
Go ahead. In favor, speak briefly.
Good morning, Chairman Edwards and members. First, we would like to thank the committee for meeting today to discuss this important issue and allowing me the opportunity to speak. My name is Sydney McCoy. I'm the Vice President of Policy and Legislation with the Virginia Coalition Against Human Trafficking, as well as a staff attorney with the Mara Legal Center, a nonprofit organization that provides free legal services to survivors of trafficking. Allowing for the vacatur and expungement of survivors' records would enable survivors to secure employment, education, and access other resources in the journey to self-reliance. And so ultimately, we are in support of the bill.
Okay.
However, we would oppose the Crime Commission's proposed amendment because it would narrow the scope and limit the availability of this remedy to trafficking juvenile survivors.
Okay, thank you. Anybody else in favor of the bill, briefly?
Jonathan Iglesias, please go ahead.
Yes, thank you, Mr. Chairman and members of the committee. Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. Many of our programs across the state currently operate human trafficking and sex trafficking specific programs in shelters for victims. And as Delegate Delaney mentioned, a lot of those victims come to us with prior convictions in which they were coerced to commit a crime, and this would help restore power and autonomy to those victims.
Okay, thank you. Anybody against the bill? Okay, is there a motion?
Move to report.
It's been moved.
Oh, hold on,
Go ahead.
Mr. Chair.
Yes, Senator Dees.
Question.
Yeah, Senator Morrissey.
Thank you. A question either for the patron or that gentleman that spoke. I forget his first name, but he was the very first speaker. Delegate, I read the bill several times, and you've also reached out to me, and I agree and support entirely the spirit of it. Can you explain to me the following, though? The gentleman who first spoke said, quote, "This is a growing problem in Virginia." I am not aware of any prosecutor who comes across somebody who they determine to be a victim of sex trafficking, who then prosecutes that individual and then gets a conviction, and then later on that person says, well, I'm a victim, and it's vacated in the circuit court. Can you explain how that dynamics comes to be?
Thank you, Mr. Chair. I would say to the senator that it speaks to the complexity of the trafficking dynamic. There are, I think when someone is engaged in sex trafficking, they are victims not only of trafficking, but of very extreme forms of manipulation and coercion, and may not always present as what we see as traditional and typical victims when they first enter the criminal justice system. It may only be after the opportunity to have an interaction with an organization or something in their life that gives them the opportunity to leave, to be freed from that trade, and to have some level of restoration where they are able to actually see themselves as a victim. So I think it does speak to some of the psychological complexity of what trafficking looks like, that victims do not always present as victims and may not always see themselves as victims at the time of their exploitation. But after the opportunity to heal and to work with some of the amazing organizations that are out there, supporting and helping extract these individuals from this trade and, get their life restored, is when they finally have the opportunity to see, how their manipulation may have affected them.
Thank you. Any other questions? Is there a motion on the bill?
Move to report.
Chair.
Sorry.
Mr. Chair,
Go ahead. Somebody, go ahead. I'm sorry. Go ahead.
Yes, Mr. Chair. Yeah, thank you, Mr. Chair and members of the committee. Patrick McKenna, Virginia Coalition Against Human Trafficking. We are in support of the bill, except one thing. This new amendment that has been raised actually would take juveniles, remove the ability from juveniles to be able to get relief under the bill. And so I don't believe that that's the intent of the Crime Commission, nor was the intent of the delegate in bringing this bill in the first place. But the way the amendment comes forth, it does eliminate that. Ms. McCoy was trying to get to that in her previous testimony. We have amendment language that actually would address the concern that may have been raised by this, having to have this amendment in the first place, and would actually ameliorate that and keep minors able to get relief under the bill. Thank you.
All right. Does anybody else want to speak in favor or against the bill? So I guess are you against the bill the way it's been amended? Or are you?
That is correct.
Vote against the
Chair.
bill? Want us to
Right.
vote against the bill?
Because of the amendment. There was no
understand.
problem before the amendment. Now minors are not able to get relief under the bill as it's amended. So we're effectively saying you can be prosecuted in the state of Virginia for a felony violation to have sex with a minor for some money or its equivalent. But the minor who's the victim is treated like a criminal and can't get relief. And I don't believe that's the intent of the delegate, nor should be the intent well as Senate. There is a way to fix this. Ms. McCoy has, and I think the delegate has the language we provided to her that would actually fix the problem, keep minors eligible to get relief. Thank you.
All right. Okay.
Mr. Chair.
Yeah, Senator Boysko.
McClellan.
McClellan.
Mr. Chair, in light of that testimony, I mean, if he opposes the bill and the bill dies, there's no way to fix it. So if there is, let me ask the delegate if she has an amendment she would like to propose consistent with what the witness just said, or wants us to move forward with the bill as is.
Mr. Chair, I mean, I think it will be a policy decision on the committee and perhaps with the consultation of your council as to the best way to move this issue forward. I certainly, as an advocate for this population for many years, hear what Mr. McKenna is saying, and we want to make sure that, we are moving forward on this issue. I think it speaks to the complexity of trafficking victims in the criminal justice system. So I will say that, I think the bill as it is, it moves us forward. It gets us in a direction where victims of trafficking now have the opportunity to have their records cleared of a crime they committed during their victimization. The council, I know, does have a potential line amendment for the consideration of the committee. So I think, Mr. Chair, what I would ask is for the committee to see the bill before you with the current amendment. I think moves us forward. It gets us moving in the right direction with the acknowledgement that there's still a lot of work to do in this space, and that's something I'm certainly committed to doing. There is a proposed amendment that, if it is the pleasure of the committee, I know council has that and can report that, and I think that would be a policy decision at this time for the committee.
Mr. Chair, could we hear the amendment, please?
Can we hear the amendment, staff? Proposed amendment.
Yes, Mr. Chair.
Charles?
So the proposed amendment would be on line 21, after encouraged. It would strike forced, intimidated, or deceived, and it would insert or induced. And then on line 22, after section 18.2, insert by means of force, fraud, deceit, intimidation, or coercion, or in which the person induced to perform such an act is younger than 18 years of age, for money or its equivalent.
Mr. Chair, I would move that amendment and speaking to that.
Okay, Senator McClellan moves that line amendment. Those line amendments, is there a second? Seconded, moved and seconded. Senator McClellan?
Yeah, thank you. Very briefly, I mean, I understand the complexity of this issue, but it is also the case that many, many, many times it is minors who are being trafficked, and I would be very concerned if we were going to carve minors out of being able to get relief, and so that's why I make the motion.
All right, is there it's been moved and seconded that the line amendment be adopted. All in favor say aye. Aye. All opposed, no. Ayes have it. So the line amendment has been adopted. All right, is there a motion that the bill as
Finance has requested this bill.
You're right. Is there a motion that the bill as amended be reported and re-referred to Finance? All in favor of the motion say, Senator Deeds makes a motion, been seconded by Senator McClellan. All in favor of the motion to report and re-refer the amendments, the bill as amended to Finance, vote aye.
It's 15, no zero.
Ayes 15, no zero. The bill has been reported and re-referred to Finance.
Mr. Chair.
Yeah, Senator Morrissey.
Mr. Chair, because it's a tradition of the Senate to extend to another senator the courtesy of allowing her to change a vote that was errantly cast with regard to House Bill 1992, having voted on the side that resulted in the bill not passing out of committee. I'd ask that this committee vote to reopen the vote so that one senator can change her vote.
Reconsider the vote. A motion to reconsider the vote by which Senate Bill 1992 failed. All in favor of the motion, say aye.
Aye.
Mr. Chairman.
Opposed, no. Yes, go ahead.
On the board.
Was
On the
Senator
board.
Morrissey on the prevailing side of that vote?
Wait a minute. You need somebody on the prevailing side. Anybody? Okay. You need some. Yeah. I don't know whether it's on which side he was on. Was this the prevailing side is the one who the bill was defeated. It was 7-1. So the prevailing side is the side that defeated the bill. Is Senator Morrissey, were you on the prevailing side?
Yes, I was voting no.
Okay. All right.
And I'm still voting no.
Okay. All in favor of the motion?
No, Mr. Chairman, you need a second from the prevailing side as well.
I don't think you do. All right. Been moved and seconded. Who seconded?
You gonna vote?
Huh?
You gonna vote?
Yeah, I'm gonna vote. Yeah. Vote to reconsider. Vote aye. Okay,
Ayes 14, noes 1.
Okay, the bill's before us again, House Bill 1992. Senator Saslaw moves to report the bill. It's been seconded by Senator Boysko. Well, first of all, we got the reconsideration. Oh, okay. Okay. I'm sorry. Okay. All right. Go ahead, John. Okay. It's been moved to and seconded to report and re-refer the amendments to. Does it go to finance? I can't remember. No, it does have to go to finance. Is that right?
Yes, Mr.
Okay. All right. So motion to report and re-refer the bill as amended to finance. That's House Bill 1992. All in favor say aye. Vote aye. All opposed, no.
Ayes 8, noes 7.
Ayes 8, no 7. The bill is reported and re-referred to finance. Okay, moving back to House Bill. Let's see, where are we now? 2150. Delegate Adams, jurisdiction over criminal cases, certification or appeal of charges. Okay, Delegate Adams.
Good morning, Mr. Chairman, members of the committee. Thank you for hearing. This is House Bill 2150, and it comes on the recommendation of the Virginia Criminal Justice Conference. It seeks to clarify specifically where jurisdiction would rest in those cases following certification from the General District Court or the Juvenile and Domestic Relations District Court, and those appeals from those same courts. And it does so by stating that it rests with the circuit court. But the language in the bill before you makes those changes under the statutes dealing with each court, and offers up 3 exceptions. And those are when an appeal has been withdrawn within 10 days, when an order's been modified, vacated, or suspended pursuant to Rule 1:1, and let's see, there was one other I thought, but at any rate, or when the case is reopened according to existing statutes. So, as I understand it, there may have been some variance across jurisdictions in those circumstances where a need arises in those cases, and between whether it's a district court or the circuit court, this will clarify that the jurisdiction rests with the circuit court.
Okay. Any questions? This is a recommendation of, it says Virginia Criminal Justice Conference. Is that right? Is there anybody?
Yes, that's correct, Mr. Chairman.
Anybody want to speak in favor of the bill? Any questions of the patron? Anybody against the bill?
Chuck Slimp, please go ahead.
All right, Chuck Slump.
Mr. Chairman, members of the committee, Chuck Slimp, Commonwealth's Attorney for Wise County and the City of Norton here, speaking on both behalf of BACA and a member of BCJC. First of all, the Virginia Association of Commonwealth's Attorneys supports this bill. I was and I'm privileged to be a part of the Virginia Criminal Justice Conference that this bill came out of. And we asked you to support the bill. Essentially, our committee was made up of justices at the Supreme Court, judges of the Court of Appeals, and judges at every level of judiciary to clarify what was happening and is happening across the Commonwealth and different jurisdictions. Different judges are doing things differently with regard to jurisdiction of these issues. Some believe that the jurisdiction should continue in general district until an indictment is brought. Some say that no, we lose jurisdiction at the moment we certify. And so essentially this is a clarification. Our committee developed two different options, one that it would remain in general district, one that it would go to circuit. We ultimately decided on the circuit option with the exceptions that are formulated here in the bill. I think they're good exceptions. I think it's a good bill. I ask you to pass it.
Thank you. Anybody else speak in favor of it? Anybody speaking against the bill?
Seth Weston, please go ahead.
Seth Weston, he's for it.
Thank you. I'm in favor of the bill. I'm a member, also privileged to be part of the Virginia Criminal Justice Conference. I was part of this committee. It does close a no man's land of a jurisdiction, and there was problems within the same circuit where district court judges and circuit court judges in the same circuit had different views on who had jurisdiction after this occurred. So we asked this to be passed and to close that jurisdictional problem.
Yeah, Seth Weston from Roanoke. Welcome, Seth
Yes,
Weston.
Good to see you.
Yeah, good to see you. Okay, anybody else want to speak one way or the other? The bill's in good shape.
No other hands raised at this time.
Anybody against the bill? All right, is there a motion to adopt the bill? Been moved and second, Senator Peake and Senator Deeds seconds it. All in favor of the motion to report House Bill 2150, vote aye. All in favor, vote no. Okay.
Ayes 15, no zero.
Okay, 15-0, the bill is reported. House Bill 2236, Delegate Bell, behavioral health dockets.
Mr. Chair, members of the committee, good morning. Mr. Chair, members of the committee, this bill would amend the Behavioral Health Docket Act that was passed last year. We have had what was initially sort of a pilot project, if you will, a mental health, we called it the Mental Health Court in Charlottesville since 2017. And it has been a godsend to certain members of our community. And last year, last year we passed the Behavioral Health Docket Act, which we hope will make it available in more places. This addresses what I hope is a transitional problem that some localities have these and some don't. It is not uncommon for the person to commit the offense that gets him into the mental health court not to live in Charlottesville, Albemarle, or if he's a student to want to return home. That's a better fit for him in lots of ways, but they don't have the docket. There's been difficulties in transferring because not every area has the resources that they need. This tries to create something that hopefully will be unnecessary in 10 years, but right now as different places ramp up, if you will, they don't have it. It says that the home court, in this case, Charlottesville, Albemarle, can reach out to the other jurisdiction, identify what that oversight would be. The other jurisdiction will say yes or no, we can do that, or we can't. If they say they can, then the court can transfer to that other jurisdiction. It also talks about DCGS developing standards and oversight over this process. I'd be happy to answer any questions the committee might have.
Okay.
Thank you.
Thank you, Delegate Bill. As the one they put in the very first mental health courts bill back 20 years ago, I think it's a great idea. Anybody want to speak in favor of it or against it? Is there a motion? Been moved and seconded to report House Bill 2236. Vote aye. And all in favor, vote aye. All opposed, vote no.
Ayes 15, no zero.
Okay, it's 15-0. We got three
Mr.
more.
Chair, thank you.
Yeah, thank you. Three more bills. But before we lose anybody, we do still have a judge to deal with. Let's do that now. As long as is everybody here? Yeah, everybody's here. Okay, Kathleen M. Uston, Esquire, for the 18th Judicial Circuit. The motion would be to certify her as qualified to the floor.
Speaking to the motion, Mr. Chair.
Senator Morrissey.
Mr. Chair, for those members that maybe came in late, this was delayed at my request so that members that were not in the room could now be here. Here's the reason that I'm opposing Kathleen Houston to be certified. We sit as a body, a collective group, both the House courts and the Senate Judiciary, and if we are really to vet and simply not sit there for several hours and let the person say, why do you want to be a judge? Then, and if we are to do our fiduciary duty, then I think in this particular case, this person should not be certified. And notwithstanding any other comments to the contrary, it has everything to do solely with qualifications. Ms. Houston began practicing 30 years ago in 1991. Currently, she has left her position at the Virginia State Bar and does, according to her resume, pro bono volunteer work and lecturing. Now, the reason that she's not, we vetted people last week and we heard to a person wonderful qualifications about the individual who is doing defense work or prosecuting work, is actively engaged in the system. As opposed to this individual, she has not appeared in a J&D court, a general district court, a circuit court, an appellate court, or a federal court to represent a plaintiff or defendant in the last 15 years. She has never represented a client in the federal court system. She has never conducted a criminal jury trial. She conducted one civil jury trial in the last 17 years. In her 17 years as a solo practitioner, before she joined the bar, her resume says that she handled minor misdemeanor offenses and traffic offenses. From 1991 until 2007, she didn't handle any felony criminal matters according to her resume. She's never served as a substitute judge. She's never published any papers, law school articles, or journal submissions. She's never published anything regarding to the 4th, 5th, 6th, or 14th Amendments. She's never served as an assistant Commonwealth's attorney or an assistant public defender. She has never represented a criminal or civil defendant before the Virginia Supreme Court, the Virginia Court of Appeals, the State Corporation Commission, the Virginia Parole Board, bankruptcy court, or any regulatory agency save the Virginia State Bar. She has never prosecuted or defended a rape case, a robbery case, a major drug trafficking case, or felony murder. She has not had to adhere to the Virginia Rules of Evidence whilst a member of the Virginia State Bar. When I asked her to discuss her choice, one significant discovery in the area of impeachment, witness credibility, character evidence, competency, privilege, exclusion of evidence, burden of proof, presumption, relevance, circumstantial evidence, scientific evidence, she responded, okay, I'll have to get back to you on that.
Okay.
I told her that recently the Virginia Supreme Court has modified the rules of discovery and asked her if she was aware of that. She stated that she was. I then asked, what is the most significant change to the rules of discovery? And she had no answer.
Senator Morsi.
So for those reasons, Mr. Chair, and only because she is not qualified, this person isn't being appointed to a general district court bench, but to a circuit court bench with less experience than I have ever seen in anybody vetting. I'm asking that she not be certified.
Okay, Senator Overchain, do you need to say something?
I don't need to. I'd like to.
Okay, go ahead.
Mr. Chairman, members of the committee, I listen with respect to my friend from Richmond, but I remember earlier in session we had a robust discussion about individuals in this committee and elsewhere reaching into other jurisdictions. What I heard are subjective views formed on the basis largely of the resume of this applicant, not concerns that arise from any in-depth knowledge of her, any long association with her. The qualifications listed by Senator from Richmond, I mean, those are nice things. If people have scholarly articles that they've written on the Fourth Amendment and otherwise, you know, that's a nice qualification, but it's nowhere on the questionnaire that is given to candidates. It is nowhere in the qualifications we set forth. I do have some association, have had some association with Ms. Houston. I found her to be a very diligent, and not involving a case against me, I would say, but I've found her to be a incredibly intelligent, articulate, skilled attorney, and you know, I'm perplexed as to the removal of her and the opposition. We heard from a number of folks who I guess are frequent testifiers in committee on judicial nominations with respect to this candidate. But what I didn't hear were people who had a professional relationship with her, who questioned her qualifications, who questioned her intelligence, who questioned her legal skills and knowledge. And based upon that and based upon my interactions with her, I support this candidate and would hope the members of the committee would, at a minimum, support certification of this candidate.
Okay, thank you.
Mr. Chairman.
We got three others, Senator Norman, Senator Stanley, Senator McClellan. Try to make it brief if possible.
Thank you, Mr. Chairman. I had the opportunity to have a discussion on Friday with Senator Morrissey about this candidate, and I appreciated very much the very frank and candid exchange that we have. I have a couple of issues, one of which Senator Obenshain touched on. If we are going to start cross-pollinating and interfering in the delegation of one another's judicial districts, we're going to open up pandemonium.
Okay, thank you.
But I haven't finished. The second point, and there's no indelicate way to say this, and I don't say it being judgmental whatsoever. The optics of taking this lady off are horrendous.
Okay. Thank you. Senator Stanley, briefly, please.
Thank you, Mr. Chairman. Mr. Chairman, I hearken to the to that day when I tried to move to certify a very qualified judge who was sitting on the bench, Judge O'Barry, the General District Court of Chesterfield. And my good friend, who I've known for years and years and years.
How many years?
Years. Took great umbrage, I think were his exact words. And in fact, he said that I was messing in his bailiwick. And the last time I checked the address of my good friend, the senator from Richmond, I noticed he doesn't live in Alexandria. And so I do believe that that bailiwick is outside his bailiwick. Okay. Long story short, Mr. Chairman, I'm going to say this. What I saw on that interview was embarrassing for all of us, save Senator Morrissey's very excellent cross-examination, which I've seen for years and years and years as well. It was embarrassment for this committee. It was an embarrassment for us all. We were a laughingstock. And Senator McDougal's colorful use of the English language to his wife and not knowing how to use Zoom summed it up perfectly. And so let us not recreate the S show. Okay. Let us do the noble thing here and stay in our lanes. Otherwise, I got a motion to make. Thank you.
Okay, Senator McClellan.
Thank you, Mr. Chair. Just very briefly, it is my understanding that this candidate was, in fact, rated highly qualified by her local bar association. So I just put that out there for what it's worth.
Okay, thank you. All right,
Mr. Chairman.
Yes, Senator Sturville, are we ready to vote? Go ahead, briefly.
Thank you, Mr. Chairman. I'd like to speak about my constituent. And I appreciate Senator Morrissey's concerned, but like Senator Norman, I believe it was Senator Gartland who set up the current rules that we operate under, my predecessor, and those rules apply no matter who's in the majority, and we have a way of doing things, and it seems to me it's worked pretty well.
Thank you.
But with respect to Katie, I've known Katie Houston now for probably about 20 years. I served on the I think it was called the 5th District Disciplinary Committee. It's like the lawyer committee that reviews disciplinary petitions, and she was our counsel on that committee, and I found the advice that she gave us to be pretty spot on all the time, and the committee, I thought, ran very well back then. That was probably 15 years ago, but she was, there was a bar election in Alexandria. The Alexandria Bar does an election process where the lawyers vote on who they think the person should be for that position. And Katie, I think, has actually won it now twice. She won it for General District Court last time, and I think for Circuit Court again. She's very highly regarded by the lawyers in Alexandria. And if there was an issue with her ability to do the job, I would expect that the bar process would have probably teased that out. And I fully trust in their process. And so, Mr. Chairman, I also support her certification.
Is there a motion to certify Kathleen M. Uston as qualified? Senator Saslaw makes the motion. Is there it's been seconded by Senator Deeds. All in favor, call the roll.
Senator Saslaw. Aye. Senator Norman. Aye. Senator Lucas. Aye. Senator Obenshain. Aye. Senator McDougall. Aye. Senator Stewart. Senator Stanley. Aye. Senator Deeds. Aye. Senator Peterson. Aye. Senator Surabel. Senator McClellan. Aye. Senator Boysko. Aye. Senator Morrissey. No. Senator Peake. Yay? Yes. Thank you. Senator Stewart, Mr. Chairman.
Aye.
Ayes 13, noes 1.
Ayes 13, noes 1. Kathleen M. Uston, Esquire, has been certified to the floor as qualified to sit on the Circuit Court of the 18th Judicial Circuit. Okay, thank you. Now, it's getting pretty close to 1:30. There are 3 other bills. I don't know if we're going to have time for them or not. We can start, if you want to, House Bill 2276, Delegate Simon.
Thank you, Mr. Chairman, members of the committee. I don't know how much time you all have left. This is the ghost guns bill. What this bill does is it makes it illegal to, does 2 things. One, it changes our definition of plastic guns to include 3D printed guns. We've had a plastic gun statute.
This is going to take a considerable period of time. I would suggest that
All right, Chairman. I'll tell you what, this may take some time. Without objection, we'll put this off to Wednesday. This is Delegate Simon's 2276. We also have Delegate Ferris's House Bill 2298 regarding muzzle loading rifles, and Delegate Robinson's 2317 Advisory Committee on Sexual and Domestic Violence. We don't have any more time, so without objection, the committee will rise. We'll meet back right after session on Wednesday. Tomorrow at 8 o'clock, the Civil Law Subcommittee has 5 bills, I believe, 5 or 6 bills to consider. Thank you. 4. Okay. This committee will rise.